Mayor's Office of Disability, Heather Cattell, responded that she no longer works there. That may be an auto reply. Nonetheless, immediately thereafter, Mr. Knatzis had contacted both the Department of Technology and our office that he was concerned that the records may be deleted since that staffer, may be leaving. So let's see, contacted us again on February 3rd. And then he gets on February 4th, receives, so that is 4 days later, receives a message from the director of the Mayor's Office of Housing, Nicole Bond. That's on page 315. And basically states their retention policy and if and requesting some clarification. So you can follow that scrolling up. I will say that this is a regular public records request under 6721. Mr. Knatzis made the request under CPRA 6250, section 6250 at sequitur, meaning the entire CPRA, under the entire CPRA. CPRA does not contain an immediate disclosure request. That is an enhancement of the Sunshine Ordinance that is allowed by the CPRA under state law. So we'll be focusing on 6721 for this file. Sorry, I'm not watching the. Yeah, okay, Member Schmidt, then Member LaHood.
Yeah, I am actually interested in asking a question of our legal counsel. Is that okay with you, Chair?
Yep, absolutely.
Okay. I don't know if this is the case where this question is a prime question, but I think we probably are going to, be seeing this situation often where someone makes a request and the volume of what they request is significant, and the agency might need to spend a lot of man hours or person hours uh, uh, responding to it. And my question to legal counsel is there a sort of a line? Is there a point where the law says that the agency is allowed to extend their time, they're allowed to object? Is there a sort of a burdensomeness standard as you would have in a civil litigation? Or in these kind of cases, is that never going to be an issue? And do we just expect, which I mean, I generally expect it, but that the agency be responsive and act immediately to respond? Any thoughts on that, legal counsel?
I know DCA Price Wolf is here in the meeting. You'd have to press *6 to unmute yourself. I don't know if DCA Castillo is here. let's see here, listed.
And I can certainly save the question because I don't know if it would affect my vote in this case.
Okay.
But I feel this like, oh, there we go.
Curious. Go ahead.
Okay.
Hello?
Yeah, go ahead.
Sorry. Can you repeat that? Do you mind?
Okay. I'll try to state it better. But I'm wondering, in this kind of case where you're talking about thousands of documents or thousands of pages of documents that are requested, and there is a claim that, oh, that there were so many hours needed to respond, to filter, etc. What would the what would the threshold be, if there is one, where the request is so massive that the agency just has to say, look, we get relief here, we can take more time, it's too burdensome, because the standards they're not clear, and there's sort of like a language here and there that might apply. Do you have any thoughts on that?
Yeah, no, that's a great question. And, I haven't dug into this area of the law in a little bit, but the last time I did, I think your instinct is spot on. Like, it's just fuzzy. There's not really case law where this direct issue has been brought up. In other words, where someone has sued a local agency when they have invoked the excuse or the justification that it's just overly burdensome, and then they won.
Mm-hmm.
So there hasn't been a real bright line drawn by a court. My sense is that this justification is used for when there's a public records request that says, hey, department, please give me every single record you have. Hey, department, please give me every single record you have related to water. Something that is just like, that's just impossible. But otherwise, I think the expectation is, if you can wrap your brain around it, just take your time and get it done. Maybe it's only, if the agency only has 3 people, and really, the agency will not be able to function on its core mission by allowing more than 2 or 3 hours a week to fulfill this request, then it's going to have to take 40 weeks because that's all the agency can really devote, right? I think it's okay if you can explain it and it's reasonable to this body and just to reasonable people. I think that makes sense. So it's a sliding scale type answer where you don't want a public records request to eviscerate an agency's ability to work their core mission. And I'm not saying responding to public records is not important, but I think like it's also reasonable for the agency to turn around and say, okay, this is our plan. We're going to devote X number of hours a week. And if they can really show legitimately that they are doing that, I think that's reasonable. What I think is unreasonable is saying, well, this just feels too big. We're just not even going to do it. When in fact, they could do it, but it would just take a really long time. You know what I mean? I think it's much the latter approach.
So, yeah, I'm hearing some kind of a sense of a reasonableness standard.
Yeah.
And can you give me anything that's in a legal provision that would support applying that type of analysis as to what's reasonable, what's not? Are we over the line, not over the line? Anything in terms of citations?
You mean you just don't want to cite me? That's not going to carry the
Well,
yeah, let me look at something.
There we go.
Now, give me 2 minutes. I have a good idea where I could look to find something.
Can I make a clarifying point? I think there's some.
No, Mr. Kranatsis.
Okay.
Your period of time for comment is over. This is now with if somebody on the task force wishes to get further clarification, they can ask, but the item is now before us. Okay, let's, if you need a little time, DCA Wolf, then let's move to Member LaHood.
Thank you. Yes, I had a question. So obviously 6721 for timeliness makes sense. I'm wondering, would we also be looking at, and I just lost my notes, 6725D, which does allow for rolling, but the idea is that you're not supposed to wait until you have everything. And it seems that even though records were ultimately provided on a rolling basis, the rolling started several months late. And I understand that there was confusion about what was required, but it seems to me that there's a violation here, that the delivering of what could have been delivered earlier should have happened, even if it was going to take longer to deliver some of the records.
Let's be clear that there is a distinction between 6721 and 6725. Okay, the rolling basis that you're identifying in 6725 referring to is only specific to immediate disclosure request.
And I see, and it was, even though it was urgent, it was not labeled as an IDR.
And it wasn't even requested under the Sunshine Ordinance. It was requested under the California Public Records Act.
Okay.
And then he filed a complaint with the Sunshine Ordinance under the CPRA. So, I mean, the CPRA is, doesn't even speak to rolling. It basically makes a mandate that it has to be provided within a period of time. Now, under 6721, we have two areas that provide timeframes. In subparagraph B, it states that if the custodian believes the record or information requested is not a public record or is exempt, the custodian shall justify the withholding of any record by demonstrating in writing as soon as possible and within 10 days following the receipt of the request that the record in question is exempt under express provisions of this ordinance. And then in subparagraph B, subparagraph B specifically referring to items that are exempt or that can be withheld. Subparagraph C is speaking about items that can be disclosed, and it states that a custodian of public record shall assist the requester on identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the custodian, whether or not the contents of those records are exempt from disclosure, and shall, when requested to do so, provide in writing within 7 days following the receipt of a record a statement as to the existence, quantity, form, and nature of records related to a particular subject or question or questions with enough specificity to enable a requester to identify records in order to make a request under subparagraph B. Okay. Further, the last sentence is a custodian of any public record, when not in possession of a record requested, shall assist a requester in directing a request to the proper office or staff person. So even just a response within a week saying, we have these records, we know they exist, here's where we think they are, and even at that point saying, this is such a large request, a voluminous request, as member DCA Wolf was saying, here's a schedule of how we're going to make this happen for you. And it basically becomes just the negotiation between the parties at that point to do that. That's why subparagraph C is written the way it is. There's an expectation that it be that the record be produced or disclosed within 10 days. So I would kind of refer to those sections. That's what I'm looking at here. I know we're for this, the response was way beyond. And on page 313, PDF page 61, you'll see on February 20th, Mr. Kranatsis writes to Iman Al-Zagari and to Director Bond that he's not received a reply in 16 days. So, and then it just keeps going on from there with Mr. Knatz's continuing to get a response. And then finally on April 14th, he does receive a response from Director Bond asking for clarification on so that's there, basically stating that, the records are being retained and filed.
I'm not sure which number this is.
And then if there is that's on page 310 or PDF page 58. That's April 14th. That was after Mr. Knatzis had made another request on March 11th, stating it's been 35 days, and then over a month later, he makes another request on another inquiry on April 14th, and then finally gets a response on April 14th. He's basically asking if there's a specific correspondent that he's looking for. His original request is well stated on three separate documents. So this is after the shelter in place order was made, but almost 2 whole months went by. Okay. Any other discussion on this? Formulating an action. Is there a motion?
Sorry to break the silence without a motion, but I found two
Go for it.
cases, Member Schmidt, that I'm just going to send you the citations. One is in the context of like someone making tax records requests, and another is in the context of someone making a public records request for grand jury transcripts. And the California appellate courts have said, look, there is an implied sort of common law rule of reason that we balance our requests against. It's about as far as the cases go in describing it. Absent limiting statutes, I think it's okay. I'm going to send those cites in a group text right now, but I found those two cases that are where the implied quote unquote rule of reason is applied in the public records context.
Thank you. That's extremely helpful, and I don't think it would affect my thinking on this case, but I'm seeing this more and more. Sure. And I'd like to. Those are something new to me, and I feel like I'm kind of at sea as to what are the outer limits here. So appreciate that. Good.
I will say that the task force has received over the years a number of responses from respondents citing the rule of reason, and we've had to grapple on how to manage a response like that. What we have been doing is requesting or asking or demanding that the respondent make specific as to why they're citing the rule of reason and to show evidence of why that they feel that this citing the rule of reason is appropriate, and we should take it into consideration. Considering that there are no guidelines or there is no law, it really becomes somewhat arbitrary. And then we would, in our wisdom and collective wisdom, can deliberate as to what that could or should be on a case-by-case basis. Member Wong.
I'd like to make a motion.
Go ahead.
So I'd like to find a violation of the Sunshine Ordinance Section 6721 for failing to respond to public records requests in a timely manner. And this is found against the Mayor's Office on Disability.
I'll second that, Member Highland.
Okay, it's moved by Member Wong, second by Member Highland, to find a violation of 6721 for failing to respond to a request in a timely manner against the Mayor's Office of Disability. Okay, discussion. Any discussion? Okay, let's open it up for public comment.
Anonymous, please.
Ms. Leger, when you're ready, handing it over to you.
Do we have, how many speakers do we have?
I'm one, anonymous.
Okay.
Are you asking for public commenters?
Yes, I just want to know how many there are so I can keep track.
Well, I'm one. Thank you.
Okay. Anonymous is one. Do we have a third?
Everyone's just on the meeting.
I'm sorry?
They don't have to raise your hand thing. People literally can talk during the meeting. In public. Like, chime in.
This is a public comment.
Hello, is somebody there wishing to make public comment? If you're not going to be making public comment, please mute yourself. There's a lot of background noise. Please press *6 to mute yourself. It toggles back and forth. *6.
Thank you, Chair.
Am I allowed to make a comment as a plaintiff or no?
No.
Okay, thanks.
Mr. Warfield, are you ready?
Actually, Anonymous
was first.
Okay.
Hold on, before you start, could whoever's on the phone with a number ending in 0633, please mute themselves?
I believe that's the plaintiff.
Is that you, Mr. Krenetsis?
No, that's
There
not
you go.
me. I'm muted.
Okay, great. Thank you. Thank you, caller. Thank you. Okay, go ahead, Ms. Leger.
Anonymous, you may begin.
Yes, thank you very much. There's a few points here. I actually agree with Member LaHood. This is a violation of the rolling response requirement because 6725D does not require or rely on 6725A or B. I don't believe you have to have an immediate disclosure request. But regardless of that, there's an additional violation here of a very specific timeline, and that is CPRA Government Code 6253C, wherein the respondent had to provide within 10 days a notice of determination of whether there were disclosable public records, or an extension of 14 days up to a total of 24 days. And that's a very specific timeline that has nothing to do with the rule of reason or volume. You just have to tell them, like, are there records? What are the reasons you might not be providing them, etc. And that is CPRA Government Code 6253C. And finally, the rule of reason is absolutely a real thing. It does apply even in San Francisco. And I'm just going to read what it applies to because it definitely doesn't apply here. And that is, the right to inspect is constrained by an implied rule of reason to protect records against theft, mutilation, or accidental damage, prevent interference with the orderly functioning of the office, and generally avoid chaos in record archives. and that's from 2 court cases and 1 attorney general opinion. And they should still have provided within 24 days at the maximum the notice of determination of disclosure of public records, an explanation, the schedule, whatever you want to call it. But they should have never started to give the first rolling response months later, and that's admitted even in their own response. So yes, you should have this motion, but you should add a violation of 6253C, which has very specific timelines about a 10-day response and with a 24-day maximum extension. Thank you.
Next speaker, please.
Please let me know when to begin.
Okay. You may begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. Reached at libraryusers2004@yahoo.com. Also PO Box 170544, San Francisco, California 941-0544. With respect to the comment of Anonymous, I completely agree. I was going to be a little more non-specific about the exact citation because CPRA does require that, excuse me, that there be a response within 10 days as to whether the records are public. They're not supposed to just leave you hanging and wondering what happened. Did I drop this into a bottomless, literally bottomless pit? There goes my timer, so I guess I'll get a thank you for the 30-second warning. And as Anonymous said, there's then a further extension possible, but a deadline posed. There were a number of things that I found troubling with respect to the testimony of the respondent, and that didn't seem to be fully taking responsibility or accountability. First of all, I thought that a lot of people are working from home, and I don't know how that would affect the ability of the staff to function. It might slow things down, but with technology, it seems as though even working from home, that it would be possible to do quite a lot. And to keep in touch with certainly as required by law, to keep in touch with the requester. I think the mayor said, the mayor's office said something about this being possibly a dramatic complaint. Yeah, it's dramatic when somebody has to wait a year. And I would be even more dramatic. I'd say it's not so dramatic. I would say people could die before getting what they're entitled to, especially under COVID. There was also a statement about taking people away from their regular duties. I think Member Schmidt was questioning that. I can't cite exactly where it appears, but I'm clear on it appearing at least in the voter handbook, and that is that responding to records is supposed to be
30 seconds.
a part of anybody's job, anybody in government, and it is not something separate or apart or secondary. And then then there was stated that we made an error. Well, it was an error. It was also a violation of the law. That's a little more serious. The attorney talked about the core mission and 2 hours a week. Again, I think that core mission includes responding to records requests. So I agree with the
Time's up, sir.
motion. Thank you. And we support it. Thank you.
Any other public comment? If you wish to speak in public comment, please unmute yourself by pressing *6. Okay, hearing no public comment is closed. I have a couple of questions here. One is for our administrator. The agenda and the complaint summary both reference 6721. Was that brought to you by the complainant?
I believe it was.
Okay.
I don't think it was an IDR. I thought it was just a basic request.
No, but did you come up with 6721, or did the complainant mention or specify 6721?
I haven't looked at the records recently, but if that's what the petitioner requested, I would have put that in there.
Okay, only because the complaint form that he used didn't specify. It just said alleged violation, public records, and public meeting.
Yeah, I probably said 6721.
Chair Wolf, this is Victor Young.
Yes.
Generally, if they just give us a general descriptions, we write in whatever sunshine ordinance most likely applies. And we do that, if it's not specific as to what code they're filing under, we pick the relevant sunshine code on our own.
Okay, because under the request that they had made, their request was under the CPRA 6250. So I'm going to redirect my question then to DCA Price Wolf. When the request is made under the CPRA, but a complaint is being brought to the task force without specifying a particular site, a particular body of law, whether it's a CPRA on its own or the Sunshine Ordinance, something specific to or unique of the Sunshine Ordinance, how should we be considering it?
So, I mean, that's a really interesting question because on the one hand, I don't think the complainant should be penalized if they, don't know every citation out there, but they feel like they're unhappy with the response that they received, and they can articulate what the problem is, but they might not have put the right citation. And then through the discovery process and going back and forth, you realize actually there's three big problems here, but since the complainant didn't put down the right one, we're only going to focus on one, right? But I think the right approach is, to the extent that you guys have identified the right statutes at hand, as long as both sides feel like they have had adequate time to address those issues, I think it's fine if it wasn't originally brought up by the complainant or respondent. So, in other words, like, as long as the respondent isn't feeling surprised or didn't have an opportunity to address these issues that are coming up, I don't think you're restricted from talking about other violations that you might be seeing or that are in the record.
Okay, that's a good response. Thank you. You just triggered another thought for me, in that it's the Sunshine Ordinance is applicable to the city and county of San Francisco. So the operative procedures should be with the ordinance, despite a request citing the California Public Records Act, because what's active here by extension is the ordinance. And I would generally think that the provisions by that extension are it should be just applied in general by the city and county, whether or not the request was made under the CPRA or under Sunshine. Does that sound right?
Yeah.
Okay, great. Thank you. All right, anybody else? Okay, Member LaHood.
Yeah. So given that we're not limited to only considering what the petitioner mentioned, is the citation I brought up earlier relevant, or do you still think it only applies to IDRs, even though it seems unclear? But I mean, I'm just bringing it up in case you want to include it. But if you don't want to, I think there's enough, obviously, to find a violation under 6721. So
I have a response to that, but I'll I'll let others speak up first if they have thoughts. No one? Okay. My response to it is 6725 was a deliberate section created by the framers. And what's inclusive, if there's a subparagraph of that, I believe in constitutional construction that it's got to be applicable. I mean, we deliberated this with regards to Prop B for the Privacy Act, allowing the Board of Supervisors to make to amend the Sunshine Ordinance. We found it to be that the any changes to the Sunshine Ordinance that could be made by the Board of Supervisors should be specific to the Privacy Act, because that's what was inclusive of the ballot measure, and we are kind of subject to a single subject type of rule here in the city. When you make motions, it should be about that one particular subject. If you've got another subject that's coming in, there should be a second motion, but not contain, no kitchen sink, like omnibus type of actions. So I contend that subparagraph D is applicable everywhere in the Sunshine Ordinance. Otherwise, it would have been repeated in 6721, and it's not there. So it may be an interesting thing for an amendment, a future amendment. But that's the way I read it. Others may.
Wait, so to clarify, you said you think it's applicable everywhere?
No, I'm saying it's not applicable.
Oh, not. Thank you. Okay.
It's specific to immediacy of response under 6725, starting with A. B it talks about voluminous nature of information requested, but that's in relation to A. It's all in sequence, and that's the way 6721 is written itself. 6721 could be seen as actually a guide in order of how a request is to be made. And so, I would say that it's 6725D is not applicable under a 6721 violation. That's just my thought. Others may want to argue against that. Okay, anything else, members? Are we ready for a vote?
I think Member Stein had something to say, but was muted.
I was just going to say I would also be more comfortable just leaving it with 6721, because I also read 6725 as just being about immediate disclosure requests, and none of the complainant's requests or none of the petitioner's requests were identified as immediate disclosure requests.
Okay. Vice Chair Yankee.
Yeah, not related to that particular topic, but just, I don't know if we want to consider possibly referencing Government Code 6253C, which kind of supplements, I suppose, what's in 6721 of the admin code, but it also ties in the CPRA as well. I don't know if anyone has any thoughts about that.
I would just ask, does it create any conflicts or misunderstandings about how the ordinance is an enhancement if it changes the time frame?
I mean, to me, I would think that my reading of 6721B and C would essentially, if those were fulfilled, then 6253C would have been also fulfilled. So I'm not sure it's necessarily required that we include it in this situation, but seeing as how there was also an initial request made under the DPRA, maybe it's worthwhile to throw it in there as well. I'm not sure they conflict, but I could see certainly a violation of both simultaneously.
But is it in our authority to be supervising the CPRA?
Absolutely.
It is?
Yes. CPRA, the Brown Act, and the Sunshine Ordinance.
Okay.
So I'll, unless you want to make, do you want to make a an amendment to the motion, Vice Chair Yankee?
I don't necessarily feel that strongly about it, since I think Member Hood's initial motion, sums up as well. But I didn't know if we wanted to. Or, I'm sorry, was it Member Wong's?
I didn't make a
Member
motion.
Wong.
I'm sorry. My mistake.
It's okay.
It was a while ago. Member Wong's initial motion. But I just wanted to throw out there. I'm fine not discussing it further though.
Okay. All right. Any last words? I'm ready to move this vote. Okay. Please call the roll, Ms. Leger.
Member Wong?
Aye.
Member Wong, aye. Member Highland?
Aye.
Member Highland, aye. Member Frazier, absent. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6721 for failing to respond to a public records request in a timely manner has passed.
And the tally was 10-0. I will also direct the Complaints and Amendments Committee to monitor this item and report back if there are any issues to the task force in July.
Chair Wolf, by monitor, could you clarify that?
Well,
Just so
it's their charge to monitor. That's in our bylaws. They regularly do. They'll,
I'm just trying to get it for the record. What are they? What is the goal of the monitoring, just for our record keeping purposes? Just so members
Since
of the public
everything
know.
was received.
yeah, that the records that were requested are received and that our order of determination is complied with.
Thank you very much.
Thank you. Okay, since we're past our 5 o'clock hour, we're going to go to public comment. So please call that item.
Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, members of the public, this is your opportunity to address the Sunshine Ordinance Task Force on any item not on today's agenda. Ms. Leger, I will hand the clock over to you.
Do we have speakers?
Sure, I'm one, anonymous.
Anonymous?
Yes,
Okay.
please.
Mr. Warfield, you're number 2. Do we have other speakers?
Zach Carnegie, number 2.
Okay, number 3, Mr. Karnazes.
And can you please press *6 for anyone on the line for accessibility purposes? That's how you.
You press *6 if you wish to speak. If you're not speaking, please press *6 to mute yourself. Okay. Okay. Anonymous, you're first. Go ahead, sir.
Hello, may I begin?
Yes, yes.
Oh, okay. Thank you very much. So first, I would ask that the task force, not with regards to the previous complaint, but in general, consider what its position on 6725 is, because the restriction in Section C, where they can't ask you for your intent, I don't think should apply only to immediate disclosure requests, and I don't see why that would be the interpretation. 6725A and B are about immediate disclosure requests. 6725D is not a subsection of 6725A or B. neither is 6725C. And I would hope that the protection of not having to ask for the intent of your request applies to all requests. And I think it actually make more sense when you have a voluminous request that is not an immediate disclosure request, and might actually be a bad incentive to say the city can only do rolling responses for immediate disclosure requests. So I'd ask you to consider that, what the task force thinks about it. I'd also ask the task force to schedule, whenever it can, Mr. Hooper's long-standing Green Benefit District complaints against OEWD and DPW. He has waited 2 years. Member Schmidt had already identified a solid violation against at least OEWD at your December full task force hearing. I don't think it's right that Mr. Hooper has to still give more lists and whatnot. There's solid proof, not only what Member Schmidt's legal argument was in December, but also because I found additional records that are exactly about that financial paper trail. They were dated before his request, and they did not provide those records. And they gave them to me, so they're not hiding it anymore. But you should schedule that, and Mr. Hooper deserves. He doesn't need to find all the violations. If you can find any violation, that should be good enough to issue an order against OEWD and force them to redo the search, including the way Member Schmidt discussed regarding contractors. Thank you very much.
Mr. Warfield, are you ready?
Yes, let me know when to begin, please.
Go ahead, sir.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also at P.O. Box 170544, San Francisco, California, 94117-0544. First of all, I'd like to second what the anonymous caller has said with regard to rolling requests. I'd also like to maybe expand it somewhat. And that is, it seems to me a business-like way of doing business would be to have contact with the person making the request so that they don't have a wall of silence as the minimum response from the agency. I know that at one point, Library Users Association started making pretty much every request an immediate disclosure request of one particular agency, because if we didn't, we wouldn't have a clue what was happening until the maximum time elapsed would happen, which would be 10 days. And then maybe we would get a response. With an immediate disclosure request, at least we would know that they got the request and that they acknowledged receiving the request, and that presumably they're either satisfying it or working on it. And I think that somewhere, if that isn't in the law already, then certainly, well, what Anonymous said is in the law, but perhaps there needs to be more, especially with long delays. It just seems to me a decent business practice. There was a mention, and I was glad of hearing about it, with regard to unapproved minutes. And one of the things that I've been puzzled about was that the first meeting in recent times that we attended, there hadn't been a meeting of that body that Mr. Highland chairs, and I can't think of it, hadn't met for just a few months, less than 2 years. And there was an unapproved minutes in there, which seemed to me ought to have been approved if it hadn't, in the full task force, under the bylaws, if it hadn't been approved. And then fairly recently, the task force was approving a committee meeting agenda minutes, that was way under 6 months, and I think even less than a month. So that led to my asking a question at that meeting, and I appreciate very much Member Yankee answering, but it was a bit of a sort of a partial answer that he cited the rule, but perhaps I didn't explain more clearly why I was raising the question. In other words, in one case, 2 years, minutes were sitting without approval. In another case, less than a month. And it's particularly painful, I can say, for our reason, our purpose, because there have been minutes that have specifically said things incorrectly, and in particular have undermined our wish to have our contact information in the minutes and have placed what little they have put incorrectly. Thank you.
We have another speaker.
Yes.
Are you ready?
Yes. Please let me speak without interruption, though. I have a stopwatch that I'll be using.
Go ahead.
Hi, this is Zach Carnazes. Thanks everyone for your efforts in a very long meeting already. But I really appreciate everyone's thoroughness here. I have some concern with what seems to be a pretty high bar that members of the public, especially disabled members of the public, need to know to file complaints with this office, especially in regards to like these really specific citations and California citations and local citations. And I just really worry because, you know, when I file public records requests, I say urgent, I'm disabled, I need help filling this out. Can anyone help me? You know, ironically, the mayor's office on disability is the department that's supposed to help disabled people, as far as I understand it, for that kind of a thing. And it concerns me that members of the public are sort of required to say the magic words immediate disclosure request, or that they lose their rights under the Sunshine Ordinance for certain things. And that doesn't seem right to me. That's kind of a worry, because how is anybody supposed to know those magic words unless they come to these meetings and talk to lawyers and stuff? That's a pretty high bar, and I'm learning as I go. You know, this is a really difficult system to engage in and understand and file with. It's just I can't imagine many disabled people are able to navigate this at all, and kind of amazing that I've been able to. So I appreciate any consideration that task force members and staff can have around that. Very different world when you can't walk or type an email, and you might struggle to wash your own dishes or cook your own food. It's a different world. Also wanted to raise a concern about the deletion of public records for government employees that leave the service of the government, that leave their job. I've raised this concern previously. I will keep raising it, that I was told by Department of Technology that records, email records of public employees who leave their job without notice to anyone in those records, or even if it's a case that they're helping somebody with, that those records will be deleted permanently from all databases within 14 days. So you might not even know that someone helping you has left their job, and all your records are gone if you haven't requested them, not even knowing to request them in 14 days. That seems to me a pretty awful use of open government and the public trust, and to erase records like that is concerning. So I hope somebody can look into that. Thank you so much for your time and attention here today.
Do we have any other speakers? Last call for public comment. Chair Wolf, I think that's it. I think you're on mute.
Thank you. Yes, I was. Okay, thank you. Let's call the next item, and then after that next item, we're gonna have a recess for 10 minutes.
Item number 5, file number 20082, complaint filed by Library Users Association against Mary Giarduzzi and the Library Commission for allegedly violating Administrative Code Section 6715 by failing to allow participation in public comment during a remote Library Commission meeting dated July 9, 2020. So on March 23rd, the Education Outreach and Training Committee found jurisdiction, the record's public, and referred to the matter to the task force.
Okay, great. Okay, same call as before, folks. We'll have the petitioner speak first for 5 minutes, and then the respondent 5 minutes, and then we'll have our discovery period, then rebuttals, and then deliberations and an action. Okay, if you're ready with the clock, Ms. Leger, we'll hear from Mr. Warfield from the Library Users Association.
Mr. Warfield, are you ready?
Yes, thank you. Tell me when to start, please.
Go ahead.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. Our contact information can be found in the agenda packet, but for those who don't go there or are listening on a recording or in some other fashion, it's libraryusers2004@yahoo.com, and also PO Box 170544, San Francisco, California 94117-0544. This is a basically simple complaint. It basically consisted of 2 sentences that we sent to the task force the day after the Library Commission meeting of the special meeting of July 9th. And I'll read you the core. At yesterday's special meeting of the San Francisco Public Library Commission, July 9, 2020, Library Users Association was denied the ability to make public comment on Item 2, SFPL Reopening Plan, which was the major item on the agenda. This was despite my best efforts to alert the Commission of my intention at this remotely conducted meeting. Thank you for your attention to this. Sincerely yours. That's basically it. Now, there's been a bunch of material that I have supplied, and also there's a bunch of material that I haven't supplied and that we haven't supplied, some of which has been supplied, for example, to the administrator and so on and so forth. So let me just point out the key documents I think that would be useful for your reference. First of all, number 1 would be P45 to 50, what constitutes fair and reasonable access to public comment. Earlier, we sent to the task force asking very much for folks to attend an actual meeting under WebEx, because we thought that it would be useful for you to attend via telephone, as we have been attending all the Library Commission meetings under COVID, and as many people are required to do because they don't have a computer, they don't have internet access, and so on. I think I've repeatedly mentioned the statistics which come from the mayor's office, fairly recent, that over 100,000 people in San Francisco don't have internet access, and certainly that minorities, older people, poorer people have the least access, disproportionately. So that was on P27 to 33. The complaint presentation, the introduction, was on P38 to 40. And we also made a little note of annotations on the library's instructions that were posted in the agenda and that were included in the library's argument, and that's on our, well, on the page P42. The annotations are hard to read. I'm disappointed that they aren't in the red ink that we actually sent. And the library's answer is on page P55 to 56. So basically, you've heard the complaint. We tried our best under the rules to make public comment, and we're not able to make public comment. I'm glad to say that approximately 2 months ago, the library changed its procedure during meetings in a favorable way. And that is, they very pointedly and clearly said that they were going to take a pause with regard to going to the next item when the gatekeeper, the person who from the library staff is controlling access to public comment, when that person would say, there's nobody waiting to speak.
30
Now,
seconds.
you've experienced that sort of thing right here, where the chair, for example, says, let's wait and see if anybody wants to make public comment. They can press *6 and so on. So at the Library Commission, they pause. And I think that was key. And I think I recognized that at the very beginning and commented that that's key to giving people a chance to make public comment and to do so better. And I'm glad the library has changed that. I think it indicates they understand they made a mistake previously.
Your time's up, sir.
Are there any persons or witnesses providing facts or evidence on behalf of the petitioner? Okay, seeing none. Is there a representative? I guess it's Miss Giarducci.
This is Margot Schaub. I'm the Library Commission Affairs Analyst. I'm here for the San Francisco Public Library.
Okay, very good. You have 5 minutes for your opening statement.
Thank you so much, and thanks for having me here this evening. In talking with folks for the meeting, I think this is one of the initial meetings coming back to do commission meetings. And looking at it is that the complainant had an opportunity to provide public comments. And looking at the minutes and videos from the meeting, he did on previous items and did not on this. It seems, we don't know, but there was a technical issue. I went over with my person who steers these commission meetings, and they showed me what it looks like when you raise your hand on the phone and when you don't. And if there's a hand there, you know who to call on, and you call on the phone number for the person who has their hand raised, but that's through WebEx. So we did not, San Francisco Public Library did not fail to allow participation in public comment. A public comment was not asked to be made. And as Mr. Warfield just said, I'm new to, well, he didn't say this, but I'm new to the role. And so I want to make sure that everyone who wants to make public comment can, and that was something that I asked us to institute, was to take a pause in case somebody is having difficulty with the technology, that we're going to be able to catch them. So again, it looks like that was a technical issue. A public comment was never asked, and so we were not able to enable Mr. Warfield to make a public comment. Thank you.
Is that the end of your testimony?
Yeah, no, thank you so much.
Okay, great. Appreciate it. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent?
No, sir.
Okay. It could be somebody other than from your department. It could be a member of the public. Yeah, anybody. Okay, hearing none, members, this is question and answer, clarification, or discovery. I've got member Padmanabhan and then member Stein.
So this question is for, I'd like to understand the technology. So this is for Mr. Warfield. Do you normally hear an announcement when you are toggled out of the queue? I have several leading questions from there.
It seems like a bad connection, but I think you're asking, do I normally hear if I am toggled out of the queue?
That's right.
Generally, the system provides a message, and presumably the toggling out of the queue is done by the gatekeeper. I call the gatekeeper. I think the technology calls it the monitor. It's the person who lets people in or mutes them out of being able to speak. So there's a couple of issues. One of the issues is, as I mentioned in some of my documents, the message that the system gives is given in a very soft voice, and there's a momentary pause, and it varies. It can vary. I don't know how it varies. I know in different meetings it varies and so on. So there's a momentary pause after you press *3, and then there's a very soft voice who has rather a long message, which I think I've quoted in the documents. If you press *3 again, you get a similar message, but one of the key problems is it's very hard to understand because there is not a silence, as the library's instructions say, but instead there is a simultaneous sound of the system soft voice saying you've basically raised your hand or lowered your hand, simultaneous with the meeting going on. And so that's very hard to understand, and even sometimes hard to know that something was actually said. I was hoping that folks would have that experience. Now, there's another thing that evidently also can happen, and that is the libraries, whoever controls it, can also just sort of gang lower everybody's hand. And if that happens at a time when either the person taking part is not attentive, or it maybe isn't going to be my turn to make public comment for a while, I may not even be at the phone. If I've made public comment and then raised my hand, I go away to get a cup of coffee or a drink of water. And now, while I was gone, there was an instantaneous message, as there actually was at today's meeting. Nobody else hears it except the people with their hands up, as I understand it. And they say the speaker queue has been cleared or some such kind of a thing. That actually happened today, and Mr. Carnazes actually spoke about it, and I heard it also. So now you've gone away momentarily or inattentive, or there was noise, or the message couldn't be heard because people were talking during the meeting. And now your status is reversed. You thought you had your hand up, but when they start calling on people, you're waiting and waiting, and then they don't call on you. So there's a whole range of problems, as far as I'm concerned, that I'm already aware of, and I certainly don't think that I know everything about the system and how it works. But one of the things that's very clear is that nobody who's on the video, for example, is going to hear my message that I'm getting saying everybody's hands have been lowered, or certainly not that your hand is up or your hand is down. I hope that explains it, and I'm very happy to answer questions to the best of my ability. I'd be very happy for that. And I might be able to play you an example of the simultaneous talking where it's very, very hard to understand what's happening.
Okay, thank you.
All right, we're getting a lot of background noise. Could folks please mute themselves? We have many people on the phone that are unmuted. Please press *6 to mute yourself. Thank you. We have Member Stein and then Member Highland.
Okay, so I just have a couple of questions for the respondent from the Library Commission, as well as one question for Mr. Warfield. So for the Library Commission respondent, I'm wondering if you wanted to comment on some of the technical issues that Mr. Warfield identified as problematic. First, the idea that *3 acts as a toggle that participants may not be aware of. This issue of multiple competing voices being heard by a caller that might make it confusing, whether they are able to participate or not, or whether they are in the queue or not. And then there was this thing about toll charges, and I'm not entirely clear about that, but I'm wondering if you have any comments on any of those technical issues.
I don't know about the toll charges, and I don't run the meetings through WebEx, so I can answer what I know, which is it's easier to participate over WebEx than it is by phone. I do know that if you press, and I should go back and say this, the library has put out on each of its agenda how you can join a call. And so we have given directions on how you join it by phone and how you join it by WebEx. One thing I'm aware of is if you are somebody who presses *3 early to say that you want to do public comment way before public comment is called, and then if you do it again because public comment is called, your hand goes down. So that could be an issue. But again, I don't know what issue Mr. Warfield faced. But again, if he walked away and something happened, that's a technical issue. That was not the library doing something. It's either a technical issue on his end or there was a technical issue in the meeting. So.
Okay, so and any comment about multiple competing voices being heard by a caller?
So right now, when I just press *6 to come back in, somebody talks to me so I can't hear what you're saying. And so that is an issue. I don't know, I'm not an expert at WebEx, but I do know that I couldn't hear you talking for maybe 2 seconds. Not even, it was about a second. So people don't cross talk in our meetings because everyone's muted until you raise your hand and you're called on for public comment. So I don't know what the cross talk would be that he's referring to.
Okay, thanks. And then my question for Mr. Warfield is, you mentioned that they are now instituting kind of a pause to check whether anyone might be having technical issues and ensuring that people can be in the queue if they want to be. Were there any other procedures that you had in mind that you feel like would be a remedy to the technical difficulties that you identify?
Well, certainly the pausing, which you do all the time, and in your meetings, even folks I understand and I can't see that are doing it directly through WebEx forget to unmute themselves. They forget this, they forget that, they whatever. It's normal to say, okay, let's try and adjust for that. And the library particularly not only didn't adjust for that, but they, a lot of their procedure is problematic. For example, when they say caller number 6 or caller number 2, your time begins now. Well, they start the timer whether you're talking or not. If you ask a question, can you hear me? The timer seems to be still going, but it makes tension over straightening out any kind of technical difficulty. And I have actually asked several times at different meetings, will you give me a 30-second alert, please? Because in a regular library commission meeting, there's a big square timer counting down, and you can see at any moment in your 3 minutes, 2:59, 2:58, 2:57. So at any moment, you can look up and see how much time you have left. At the supervisors, similarly, the podium has a countdown, and at the task force, you routinely give 30-second warnings. The library commission won't even answer. I've had several occasions where they will not answer. I leave a blank few moments, and then I say, well, I guess I won't get an answer. And I've had the city librarian say, Mr. Warfield, you can go ahead, or go ahead and speak, which is frankly, pretty insulting. As far as Ms. Schaub's understanding of contention, which is what happens when two voices are speaking at the same time, I'm not sure what she is referring to. If I press *3 or whatever I have to press *3, I can press that any time in the meeting. Up, down, up, down. I can do it throughout the whole meeting if I want to. Not that I'm doing it. But if I do that, for example, after public comment is over on item 1, and I figure, okay, next up is item 2, they're going to discuss this one a little and then go on, I press *3. I'm pressing *3 while the commission is talking about, let's say, item 1, and they're talking the whole time. There isn't a lot of space where they're talking. They talk. And so I'm going to hear the message about my hand up or my hand down while they are talking. So, those are some of the problems. I could probably give you a list of other issues, but right now, you mentioned, I believe, the toll charges. And by the way, I'm glad you're asking. I'm grateful you're asking. It is something that I found a problem also, and mentioned it. Toll charges meant that if you wanted to participate in the library commission meeting of that date and the prior date, and I'm not sure how many dates further, you literally had to call a toll number which was in San Jose. And I called up the O operator multiple times, and they told me from a AT&T landline, which I'm speaking to you on now at home, your cost is 59 cents a minute plus tax. Well, that's kind of a lot. And they've changed it since then to a local call, but at that time, and I'm looking at the library's response, I don't know if this was the current response. I'm looking at page 55. And let me just see where the number is. So yeah, on page P for Peter 55, the library's own response says, right up in the agenda, listen and public comment call-in. Should I pause for a minute to let people look at it? So the number is 1-408-418-9388. Then it gives the access code and so on. So you had to spend a fortune or find some other way. Frankly, I don't even know that that's legal within the concept of sunshine, that you should be able to attend a meeting without any charge. But that was certainly a very steep thing to do. And for those who might have a cell phone connection there where it's cheaper or no extra charge for them, they're then forced into using an inferior kind of a connection where it's even hard to understand when there's no crosstalk and no contention with any other voices at the same time as the meeting voices. So those are some of the things that could go on. Yeah.
We have other folks that want to ask questions.
Sure. Yeah, please.
Okay, thank you.
Okay, Member Highland and Member Schmidt.
I had a question for Ms. Kaplan. I think you said in your opening preamble that public comment was not called at that particular item. Did I hear that correctly?
Are you talking to Margot Shaw or is there a Kaplan?
I apologize, Ms. Shaw. Yes.
Oh no, public comment is called on every item. I know Mr. Warfield had made public comment on the item before and on items afterwards, so we just knew that he had the capability of doing that. So
okay, I thought I heard you say that perhaps there's a technical glitch where public comment was not called on that item. Did I mishear?
That's not what I didn't say that, but what I did say is that if you can, as Mr. Warfield said, you can toggle on and off by raising your hand. We can't do that to him, but he can do that, or a commenter can do that. So if he did if he pressed *3 and then accidentally did it again and walked away and got coffee and didn't hear what have you, then he did not make a public comment, but we do call public comment on every item, and we did that day.
All right. Okay, that's all. Thank you.
Sure.
Yep. Member Schmidt.
Yeah, two questions for Mr. Warfield. First, about the meeting in question, that specific meeting, that specific day. So were you did you have to call a 408 toll number to get into that meeting?
Yes, absolutely. That's the only number that's listed on the agenda that I could see was available. Yes.
So I assume that you ended up probably with a charge on your phone bill to call in.
I decided that for the sake of the enormous charge, I would be willing to accept a very degraded flip phone, which would cost me less.
Okay.
But it was still a cost. It was still a greater than. It was above zero for sure.
Now, when you had the difficulty where there was an item and it was a point where public comment was being taken, and you weren't able to make a comment on that matter. Were there subsequent items at that meeting where you were able to make comment?
Yes, absolutely. In fact, I'd made public comment on the first item and the subsequent items, of which there were, I believe, 2, and at the first meeting in June that they had under COVID. So I made public comment there as well successfully.
Okay. Did you bring up, in the subsequent public comments, did you bring up this issue that on a prior item, your comment was not made, and so you needed that problem remedied?
I certainly did. On the immediately following item, I spoke up immediately. And by the way, this is another tension point. How much of my time do I want to spend complaining about some kind of a problem that I've had on a previous item? And am I going to run into flack from the library commission over, well, that's not relevant. The issue now is item 3. But I certainly did make a comment, and I believe I even put my finger on something that ultimately 9 or so months later they've done, which is take a pause. And if anybody has misunderstood or been misled or just doesn't know or can't remember or whatever it is, their status, just as you guys routinely don't remember that you're muted and somebody has to say, hey, please, okay, fine. That's an accommodation. That's a reasonable thing. I wanted to say something about Ms. Schaub, that she said they can't change my status. That is not true. You've just done it today at the meeting. The library is able, without anybody in the meeting hearing it, as I understand it, and I've experienced it, at this and other meetings, where the library gatekeeper who controls admission into the room for sound, for making public comment, is able to lower a person's hand or lower, I believe, everybody's hand whose hand is up. So the reversal is entirely possible within their control.
When you mentioned at a subsequent public comment that you had not been able to make your public comment on the prior item, did anyone with the commission allow you to go back and to put your comment on that item?
What a lovely thought. I appreciate that very much. No, absolutely not.
Accommodate
Pardon?
you in any way?
That's correct.
Okay, got it. Okay, thank you. I think that's what I was looking for.
Thank you. Member Forsley.
Hi, yes. I was wondering, the library commission or library representative, do they remember Peter Warfield subsequently referring to not being able to make public comment?
I'm new to this role, but I did watch the commission meeting. And so I did see that he seemed frustrated that he couldn't make a comment, or that he said he couldn't make a comment.
And so just a follow-up question, since you had seen that portion of it immediately preceding that, you state that public comment was called for in the item that he was referring to?
I'm not sure I understand your question, but if what you're asking is, when I watched this, I saw that he was able to make public comment throughout the commission meeting. Yes.
Okay, yeah.
Any other questions on discovery, folks? Clarifications? All right, I have one, Ms. Shaw. What system do you use exactly?
The platform is WebEx.
Okay, and is the phone service also provided by WebEx?
Through WebEx.
Okay. I thought I heard you say that that the phone service was not WebEx before.
I
Right.
don't have enough technical no, it's a WebEx platform, and that's what we use to run our commission meetings. So the phone is part of the WebEx system that they provide to us when we use their product.
Okay, great. Okay, that's what I wanted to know. Okay, thank you very much. Members, are we ready for rebuttal? Your last chance for Q&A. Okay, let's move to rebuttals. Ms. Shaw, you go first. You have 3 minutes.
Are you ready?
Yeah, so Margot Shop's going first.
Yes.
Okay, I'm ready when you are.
Okay, go ahead.
Just wanted to reiterate, I'm new to this role, and we did institute a pause to make sure that we did not miss people who were having technical issues with the WebEx platform, so they could make public comments. We were not missing people making public comments, although this is the only one I've heard of since I've started. And thank you for inviting me tonight and hearing me, and I have nothing further to add.
Thank you. Mr. Warfield, you have 3 minutes.
None.
Can you tell me when to start, please? I'm not clear.
Yeah, you can start now, Mr. Warfield.
Thank you. First of all, the calling of public comment, that is done, but the opportunity to make public comment requires me to be able to speak. If you locked the door and call it a technical problem, well, yeah, I can't walk through a door. I'm very interested. I'm glad Mr. Wolf asked about what system was being used, because I heard it too, that we're not using WebEx. And now it turns out we are. I'm interested in what the technical issue is, but in any case, as far as I'm concerned, it is the responsibility of the Library Commission to provide an opportunity for public comment, whatever it takes. And certainly if there was a problem with a microphone, if somebody gets up there and they're too short or too tall, people will say, please adjust the microphone, or if somebody is slow in getting to the podium, and so on and so forth. I provided in my documentation that the library's argument about nobody else had a problem, first of all, it's irrelevant, because all kinds of things can be different for different folks, different circumstances, statuses, hands up or hands down, and so on. But in fact, Mr. Hasbrook was called on specifically to make public comment, and about 17 seconds of waiting through silence found that he wasn't able to make public comment. And so he came back on as something like the seventh person speaking, and I'd be glad to play it for you if you let me play it, but I have it on page your P49. Item 13, others have complained about public comment during COVID-19, including 2 people at the July 9th, 2020 meeting that we attended. And the first one I said 13A, Edward Hasbrook, exactly at 10:07. He was called to speak on. There was a silence. No, it didn't seem like it was happening. And then later, 7 minutes later at 17:10, if you play it yourselves on one of your computers, you'll hear him say, very snippy and very not happy. I did try to call in on WebEx, and that wasn't working, for your information. And by the way, they called on him by name at 10 minutes and 7 seconds into the meeting, and he wasn't to be found. So he very snippily said it wasn't working. And then Anonymous also complained about the barrier of expensive toll charges, and that's actually mentioned in the minutes of the July 9th, 2020 meeting, if you want to look that up as well, and I actually appreciate it if you would. So we did our best against a lot of uncertainties and odds. I would certainly ask what were the technical issue that Ms. Shaw is blaming for this. Let's hear it, and I think they still are responsible, even if no matter what the technical cause is. Thank you.
Okay, members, time for deliberation and an action. So I have one thought about this is, at the time that they were of these meetings that they were using, not just in one meeting, but in multiple meetings, a long distance number, and considering it's out of the what they call LATA, so local area telephone access or something like that, or local access telephone area or something like that. If you're using a landline, it is a long distance phone call to 408, which is San Jose. It is quite expensive. I agree with that. There cannot be an assumption that everybody is using a cellular phone, which most plans include long distance. So I'm wondering if that might be considered a barrier to access of a meeting. It's an interesting point.
Member Schmidt, I'd agree that looks like a barrier to access that is probably a violation here. It's unclear if it comes within the scope of the claim itself, but it did happen on the day of in that moment that he was being charged money to attend a meeting by calling a 408 number.
Okay, so if there's no other deliberation or discussion, is there a motion? You need a motion one way or another.
I will make the motion. This is Member Schmidt to find a violation of 6715, failing to allow participation. And at least at this time, I'd also like to make a finding of a violation of 67.13A, requiring a payment or purchase in order to attend.
Okay, moved by Member Schmidt. Is there a second?
I'll second. This is Member LaHood.
Moved by Member Schmidt, second by Member LaHood, to find a violation of 6715 for failing to provide opportunity for public testimony, and a violation of 6713A for requiring a payment or purchase to attend a meeting. Any discussion, debate on the motion? Vice Chair Yankee.
Yes. I don't know if this would apply, but maybe it's worth discussing. There's 67.6B, talks about a lot, but ends with all meetings of its policies bodies shall be held within the city and county of San Francisco. And so I wonder if the fact that this area code is not within the city and county of San Francisco, if that provision would virtually apply, for lack of a better way to put it.
Are you making an assertion or are you asking a question?
I'm raising a point of discussion.
Okay.
I don't know if anyone else has a thought on that.
Well, we have a motion on the floor. If let's continue with that motion, unless you're one of the maker or the second wants to amend the motion to include that. Otherwise, I would say let's deal with the motion on the floor. We could discuss it afterwards. If it's another motion would be made, then we can do that too.
That works for me.
Okay. Any other debate or discussion on the motion? Okay, let's call public comment. Public comment is on the motion to find a violation of 6715 and 6713A. Ms. Leger, I hand it to you.
Do we have any speakers? Calling for public comment on the motion. Find a violation of 6715 and 6713A. Do we have any public comment?
Yes, anonymous, please. Hello?
I hear you. Yep, just a second. Can you hear me?
I can hear you now.
Okay. You ready?
I am.
Go ahead, sir.
So exactly what Mr. Warfield said happened to him just now happened to me. I was sitting there saying anonymous number one, but I had to swap my star six back in, not realizing I had been star six in between. But this violation is important. I would say both the ones that you're in your motion now, which I support, but also the one that was suggested about the location being inside San Francisco, because it's not just about some meeting that happened months ago. This is how the city is going to set its standards for other virtual meetings and if there's another pandemic or emergency. And just like in a physical, real life meeting, if you ask for some public comment and someone is, sitting at the back and they need a walker to get to the front, and they say, well, there's no one at the podium, let's move on, that would not be giving that person a meaningful opportunity to comment. And the same exact thing applies to, for example, as I just experienced having to press star six, I just had to sit through some comment that I'm saying, and I don't know if you know I'm trying to comment. And so this matters, and it's the meaningful opportunity to comment that matters. Just performative asking for and then moving on doesn't count. And by finding this violation, you'll ensure that all other commissions properly set their rules going forward. Thank you.
Do we have any other public commenters? Chair Wolf, I think you're on mute.
Thank you. Let's close public comment and any other last debate, or are we ready for a vote?
Member Schmidt, I really like what Member Yankee said, and it's a good idea. I think it's ambiguous, though. Where is a meeting held, if anywhere, if it's not held physically? I'd be willing, if others want to add that to my motion, but I don't know if it's that clear whether there was a violation of that. So that's my response on that.
Well, I would say, the meeting in question was not during the pandemic. The meeting in
What?
question, was it? Oh,
Yep.
yeah,
So July 2020.
July 2020. I'm sorry. Yes, it was. Okay. I think so then I'll say this. Because virtual meetings were allowed under the shelter in place ordinance or declarations, it's a bit of a reach for me to say that the meeting didn't happen, in a physical place. And I would at least say that the access to it needs to be in the locale of San Francisco, which would require a 415 area code to access. I can't even think of an analogy that I can bring to that. I think it's just as plain as that is. So I would hedge against Vice Chair Yankee's suggestion. But I do understand it. I think that is important. But I think as long as access to a San Francisco meeting remains free of charge, that it contains all the ability to access from within the confines of the city, I think under the shelter in place order, I think that would be reasonable. I think outside of it, like if the shelter in place order was lifted as it's planned to be on June 15th, and city buildings are still not open for public meetings, and we're still doing this remotely, then I think there's an issue. We can take up that issue at that point if meetings are happening not in the confines of the city. I'll stop there. Member LaHood.
Yeah, I just wanted to support that. I agree, and as the second on this motion, I agree with what you just said, and that either a 415 number or a toll-free number to ensure that there were no barriers to access would have been sufficient. But anything where some members of the public, in order to call in, would have to pay is not acceptable.
Okay. All right. Any last thoughts? Are we ready for a vote? Okay. Please call the roll.
Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Frazier, absent. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Yankee, aye. Member Highland?
No.
Member Highland, no. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6715 by failing to allow participation in public comment and 6713A requiring a payment or purchase to attend the meeting.
And the tally?
9 yeas, 1 no.
Okay, thank you. Okay. I will initiate a recess for 10 minutes. It's 7:05. We will return at 7:15. And with that, we are in recess. I think it would be a good idea if we call the roll, make sure we still have a quorum.
going to wait a few minutes, or would you like me to call it now?
No, call it now. Call for the recess to be over on 7:15.
Member Frazier is absent. Member Padmanabhan?
Present.
Member Padmanabhan present. Member Neighbors?
Present.
Member Neighbors present. Member Stein?
Present.
Member Stein present. Member Forsley?
Present.
Member Forsley present. Member Schmidt?
Present.
Member Schmidt present. Member Wong?
Present.
Member Wong present. Member Yankee?
Present.
Member Yankee present. Member LaHood?
Present.
Member LaHood present. Member Highland? Member Highland?
He's muted. But go to the next person.
Chair Wolf?
Present.
Chair Wolf present.
Okay, we'll note that Member Highland is absent, and when he arrives, we hope that he will announce himself. If not, he'll remain present, absent. Okay. I just need to close my door. All right, come inside. Okay, let's call the next item.
Item number 6, file number 20068, complaint filed by James Chafee against the Library Commission for allegedly violating Administrative Code Section 6714, failing to make audio recordings available on the website, 6721 by failing to respond to a records request in a timely and complete manner, and 6729 by failing to maintain the Library Commission website. Matter was heard on March 16, 2021. Complaint committee found jurisdiction, that the records are public, and referred the matter to the task force for hearing.
Okay. Before we begin, I'd just like to note that in Mr. Chafee's submission of the complaint of February 4th, which is on page 71 of our of the document, and page 5 of the PDF. It states that the violation is against the San Francisco Library Commission, the president of the Library Commission, Dr. Mary Wardell Giraduzzi, and secretary to the Library Commission, Sue Blackman. I'm sorry. So just so we're all clear as to who the respondents are. Okay. So it's a regular hearing. We'll start with 5 minutes of introductory testimony, and we'll move on from there. Mr. Chafee, are you present? Star 6 would unmute you. Mr. Chafee, are you present? Ms. Leger, did you receive any communication from Mr. Chafee?
Not about today's hearing, no. The only communication I received was the letter that I sent to you.
Okay. Which made no mention of,
correct. But I haven't heard.
Matters, I've been asked to say something on behalf of Mr. Chafee's reading.
I'm sorry, who's that speaking?
This is Peter Warfield.
Do you have any communications from him regarding his presence?
I spoke with him about it, and he had also sent me a short email. Basically, he said that he asserted in a previous email that he didn't believe there was a requirement legally for anybody to attend, and that there was no need to attend. And since he had not gotten a response, he felt that there was basic agreement with that, and not something contradicting it, so he didn't. And of course, he had said he didn't want to.
Okay, I received that same. Thank you, Mr. Warfield. Appreciate that. I received that same communication, but it didn't. It wasn't clear to me that it was specifically related to this particular case. It seemed to be a general statement. Maybe I missed something in the communication, but I'm just want to check our complaint procedure. Our complaint procedure makes a requirement of that, being that the ordinance allows us to have a hearing. We've been operating in this way with this requirement for a very, very long time. Recognizing that Mr. Chafee's history with the Sunshine Task Force, being a member and a chair since the beginning of its inception. You know, I'm not necessarily recognizing how this is.
This is Member Stein. Can I just ask, where does it say that in our bylaws or wherever, where does it say that a complainant has to be there?
It's in our complaint procedure, number 7. Section C, paragraph 7. Attendance and requirements for complainant and respondent. A, subparagraph A. Unless otherwise provided in these procedures, the complainant and respondent are required to attend the hearings regarding complaints. However, at the discretion of the task force or its committees, accommodations may be made in response to special circumstances or requests made to the complainant and or the respondent. And then B, if the complainant fails to appear at a SOTF or committee hearing regarding their complaint without prior communications, the matter may be filed and dismissed without prejudice. What it means to be filed, it may be closed. Can everybody on the phone please mute themselves? Please press star 6. Specifically, the phone number ending in 6151. Thank you. Okay, if the we had complaints dismissed without prejudice are considered closed and no further actions are to be taken. The complainant shall be notified of the action and may request their complaint be reopened in writing if requested within 60 days. The complainant may also refile the complaint on a future date, period. The task force or its chairperson shall determine if the complaint shall be reopened. How shall we proceed, members? What is your pleasure? And this was, the letter was addressed to myself and to members. I'm not clear if it was sent out to everyone.
Chair Wolf, This is Member LaHood. I don't know if you can see because it looks like we don't have the tile view anymore, but Member Forsley has a hand raised.
Oh, okay. Member Forsley, go ahead.
Hi. I was wondering if there's a possibility that the complainant didn't know that they were, supposed to appear, and now that we're saying that they have to appear, if we could potentially just let them know that the case would be fine as long as they know they have to appear next time? Or is that not, if that's not the procedure, I would just prefer to do whatever the procedure is.
Well, I would agree with you for, but in this case, with regards to Mr. Chafee, he is so knowledgeable about the task force because of his participation on it, involvement, and probably when this complaint procedure was created, either at the time or soon after.
And he's gotten in writing that he has to appear.
He got it. Oh yeah, he had. That's why he sent a letter. Oh wait a second. This is not the letter that I was referring to. He said in his letter he was challenging our ability to require the complainant to appear. Let me see if.
Yeah, it doesn't seem like the ordinance itself requires that the complainant appear, only the respondent, only the government agency, but it's in our bylaws that the complainant is being asked to appear. I think it's a problematic bylaw personally, but it is in there.
Well, we have been back and forth on this. We've had changes to. It's not a bylaw. It's part of the complaint process.
Okay, sorry. Got those documents together.
Yeah. So the
procedure.
We have because there were mostly city staff or respondents that complained about having to come to 2 meetings. We've gone back and forth as to which meetings that are they required to attend. And we made those changes more at the behest of the respondents. So if they didn't want, we basically have it now where they're not required. I think they're not required to attend a committee. Oh no, they're required to attend both. It used to be they weren't required to attend the committee meeting and then not the actual hearing, and we've done it the reverse also. And the problems that we were having is if they didn't attend the committee and we weren't able to get all the full information, then we'd spent way too much time at the task force doing discovery at the task force hearing. Vice versa, not getting enough information at the committee meeting, if they don't show up at the full hearing, then we get all this. Then we get not enough information to be able to have a fair hearing. So, yes, Member Forsley, you're on mute.
So I guess my question is, do the place where it's written that they have to appear, does that particular statement, whatever it's called, override the Sunshine Task Force ordinance itself?
Well, the ordinance is in 6721. Let's see, it's 6721E. It says if a custodian refuses to fail to comply or incompletely complies with the request described in subparagraph B above, or if a petition is denied or not acted on by a supervisor of public records, the person making the request may petition the Sunshine Task Force for determination. For the records, the task force shall inform the petitioner as soon as possible within 2 days after its next meeting, but no later case than 45 days from when the petition in writing is received of its determination whether the record is requested or any part of the record requested is public. And then skipping down,
It basically says in the last sentence or two only that the custodian of public records should, from basically the respondent should attend the hearing. It doesn't specify that the petitioner has to attend the hearing.
Well, true. I mean, it at the last sentence of the section says, or two sentences says, where requested by the petition, Sunshine Task Force may conduct a public hearing concerning the records, request denial, and an authorized representative of the custodian of public records shall requested shall attend any hearing and explain the basis for its decision to withhold the records request. But be it as it may, our rules are, we've created rules around how to conduct the hearing, and it includes having the person who makes the complaint attend. I mean, I don't know that any other administrative process would do that. I mean, we provide the ability to make anonymous complaints, but I don't think a court or any other, even the ethics commission, requires it allows for one or the other parties not to attend. But I think in this case, we have in it the option for the complainant to have the case reopened.
This is Member Forsley
Yes.
again. I guess just goes back to that same question. Do our bylaws, governing documents, etc., whatever we're calling it, override like the law? So it would be like if the person wanted to like potentially just refer to the ordinance and say, I don't have to show up, do our particular bylaws or documents override that? And
No,
or
it
are you
doesn't.
saying that we can decide?
Our governing, these documents, our bylaws and our complaint procedure do not supersede the Sunshine Ordinance. But that means that the question is if a person is going to challenge the interpretation of the Sunshine Ordinance and we don't agree with that, then what? I mean, just because somebody says that they think it's to be interpreted some other way doesn't mean that it's correct.
That's true, but I think the discussion that you and Member Stein were having is that it doesn't like specifically say they have to be here, just the respondent has to be here. So I guess we probably should be on one accord regarding if the respondent just has to be here or not.
I mean, I just want to say I understand why it's in the bylaws and I understand your explanation, Chair Wolf, of why the task force has found it important to have both parties there for getting full information and for, hopefully not wasting time. But I also feel like it could be seen as a barrier to complainants because it's a high bar that we're asking of people that want to appeal a decision, just in terms of the amount of time they have to spend, writing up a complaint and then coming to, at least one committee meeting and then coming to a multi-hour task force meeting. So I mean, I'm kind of the mind, like in an ideal world, you might say to them something like, look, we recommend that you come. You have a better chance of succeeding if you come, but not necessarily requiring it. But I understand that it's there in our bylaws. So, I mean, I can go along with that. But I do see it as a bit of a barrier to the complainant. And I feel like it's much more important to have the city there to be held accountable because that's sort of the whole aim of the Sunshine Ordinance.
Okay, and we've got a couple other hands, but just again, a correction. It's not in our bylaws. It's part of the complaint.
Sorry, in our procedures. Yeah, in our complaint procedures.
I would just additionally say that I don't think any hearing that happens would actually hear the complaint without the person making the complaint. The other problem we have is if people do this at their peril if they don't want to show up. And our complaint procedure provides the ability to have it reopened if they feel that it was incorrectly managed. And we have a reconsideration process at the same time. But if for some reason if we move ahead to hear this file in this hearing, and it doesn't go, it doesn't support the complainant's findings, then if they find that we're wrong because they weren't here to explain it, then they can file for reconsideration. And that is an additional waste of our time. And I think that that's inappropriate. If people are going to go to the trouble to make a complaint, they should, like we are having as volunteers to be here and to hear those complaints. And we have an agenda that gets sent out, and their notices of appearances go out before the agenda is posted to make sure that they know that their hearing is coming up. We bend over backwards for this. So I think it's, I think it's incumbent upon people to appear. If respondents don't want to appear because they want maybe to declare no contest or something like that, that's a different story. But we are here for the public, and we give the public, this wonderful opportunity that doesn't exist in most cities. So I'll stop there. I've got Member Schmidt and then Vice Chair Yankee, and then Member Neighbors.
Yeah, Member Schmidt, I'm going to sort of put in my 2 cents on this, which is when Member Stein spoke up, I was pretty much right there. One is it's a rule, but there's no sanction. There's no unless the rule says that we have to act a certain way if they don't show up, then it's a rule that we can say, oh, he didn't show up and he violated the rule. But that doesn't necessarily mean to me that we therefore either dismiss a claim or don't hear it, etc. It seems to me that the claimant has had his opportunity. He's chosen, whether he's protesting or not, he's chosen to not be here. But if he's got a valid claim, let's hear it. And I think that the idea that people can put in a claim because they feel like they've been denied records, they've been denied access, he's put in a claim, and he wants an answer. That's my sort of chiming in on this.
Okay, Vice Chair Yankee.
Yeah, I was just looking at the complaint procedures, and I think I was on the Rules Committee when we last kind of talked about this, and I think both sides that have already kind of been tossed around were discussed. I mean, we discussed, what happens if someone wants to lodge 10, 15, 20 complaints and they never show up for them. That's a lot of work, like we spoke about, Chair Wolf, on this task force for someone who may not necessarily be invested in time besides sending, a variety of emails and so forth and so on. But we also recognize that, this can obviously take a lot of people's time, and going to multiple meetings can be difficult. And so we looked at 7D, talking about just having them, and it says after initial in-person appearance, the complainant may authorize the SOTF to proceed with the hearing in absentia on the complaint without a complainant's presence at the hearing. And so I think was kind of the middle ground, if I recall, that we discussed at the time, having them be invested to a certain extent, but then realizing that these things often can be continued on from meeting to meeting and so forth and so on. And it gives that person the opportunity to say, go ahead without me, but at least, has them be part of the process as well, at least at the initial stage. And so I guess my question, since I wasn't on the committee that initially heard this, was, did the complainant appear at the committee stage to discuss this?
No.
I don't. Okay.
Okay, member Neighbors and member Highland.
Thank you. First, I just wanted to point out that the complaint procedure itself is in the bylaws. And so in that sense, it does appear there with the presumption that the complainant is there in the steps that are followed through that. And there is no alternative procedure. So while that procedure is codified, no other procedure without a petitioner is codified in that way. So I think that's an important consideration. And then the teacher in me has to say that, I think there's an assumption here about where burden lies for different folks. And in my years in watching this task force, one of the things that I've noticed is that some of our petitioners have real strength in putting their written packets together and their arguments. Some of our anonymous petitioners specifically basically have written out packets for us that allow us kind of a roadmap of their complaint, whereas other folks really thrive in the verbal part of it, but it's more of a burden for them to put the written packet together. So I don't want to assume that that we're putting an undue burden on folks to show up at the meeting. I think we're putting an undue burden on them to put together a packet as well, or we're putting a burden there. But we're actually giving them a choice of where they can put their strengths and put their and being here and being able to answer those questions and fill that information out has been really important for some folks as well.
Okay, member Highland.
Yeah, going back several years when we, I guess, codified this, if you like, I think we were leaning heavily towards the the plaintiffs. In fact, there was some early language about requiring the respondents to show up, but not necessarily the plaintiffs. I do remember going through those permutations. But I think, Vice Chair Yankee gave a nice balancing, saying, at the time when we did this, we did have a lot of, multiple filers, so to speak, if you like, and we're trying to balance the burdens of the task force, and that was at the time what we came up to be the fairest. However, I do remember, and we have done this in the past before any of your times on the task force, if petitioners ask us to essentially run with it, we can, and we have done that. So I think that's guidance to us, but I think we have, as Chair Wolf said, we have the power in us to go ahead and hear this, whether the plaintiff is here or not. And I think in his letter, his language saying it stands alone, I'm happy to take that as, run with it, execute this file. That's how I see it. Thank you.
Just before we have two more speakers, I just want to respond to two things. One is in our bylaws, it's the hearing procedure that is in the bylaws, not the complaint procedure. And also to Member Highland's point, we've always gone ahead in absentia when a respondent isn't. That's in my experience. It's been very rare that we've taken a case. In my experience, and I'm missing 4 years here since 2005, that we've taken any case where a complainant was in absentia unless they requested it or allowed it after they had already appeared at a complaint committee. It was never where they were in complete absentia. At that point, we would consider it they have no interest in carrying their complaint forward. And that's why the complaint, in the complaint procedure, it gives so many, like at least 3 opportunities to be able to have the case reopened in that way. So at least show up for the initial meeting. And if they feel that this is an open and shut case after the initial committee hearing, then fine. But at least show up to one. Okay, next we have Member Stein and then Member Forsley.
Yeah, I just want to say, because I went back to look at Mr. Chafee's letter, and while it's true that he doesn't specifically request not to attend these meetings, this is what he says. You know, he's referring to a letter that he was sent from the task force. He said, "This letter indicates that, quote, your attendance is required," unquote. There is no justification for such a requirement. My complaint speaks for itself. The purpose of a complaint is to bring a violation to the attention of the task force. I am not a prosecutor of sunshine violations. I am not seeking damages. The aggrieved party is the general public, of whom you are presumed to be the representatives. The only effect of such a requirement is to create a barrier to enforcement. So I think while he doesn't specifically request not to come to the committees, he certainly makes it known that he feels that his case stands for itself in writing, and that he doesn't feel that he needs to be present for that case to be heard.
Member Forsley?
I was just going to say again, just going back to just like which thing overtakes which other thing. Like if our complaint procedure can overtake, you know, the actual ordinance, then we should go with that. If it's more, or the other way around, we should just go with whatever the rules are. But if we have more flexibility than that, I would think that we would want people to be here. In like if they made the complaint, they would want to be here. And I think that just what Member Stein just read regarding that his duty is to bring information to the task force attention, I don't necessarily believe that's what, you know, a complaint is supposed to do, because there's other, you know, governmental, you know, regulatory agencies that kind of handle situations like that. But I feel like we should definitely have the person who made the complaint here. I mean, that's it.
Okay, Member Schmidt?
Yes, just as to Member Forsley, let me say that to me it's pretty clear that if there's any contradiction between the ordinance and the complaint procedures, the ordinance wins. The complaint procedures are you know, you could say there's 5 or 6 tiers of law here, starting with the U.S. Constitution, California Constitution, state law,
Charter.
Charter, ordinance, and then anything that's a regulation or a rule of some kind is definitely inferior to anything in the ordinance. Although you'd have to find, I think, whether there is actually a contradiction. I don't know if we've necessarily identified one yet.
Okay, go ahead, Member Forsley, and then I'm gonna close it so we can figure out what to do. Go ahead. You're on mute.
You did, yeah.
You're on mute.
That's what I would assume, and I would assume the law would kind of overtake that. And I think that what some of the other members were saying is that actually in the ordinance it does say, it doesn't specify they have to appear. So I mean, we would probably just, you know, have to go with that, unless also in the ordinance it says that we could override that, or just, you know, vote so their case gets closed so they don't keep doing it or something.
Member Padmanabhan.
So my point is that he has, Mr. Shafee has also discussed this with Mr. Warfield and has appointed him as a possible representative, or him, you know. So I feel that in that instance we should go on.
Okay. All right, I will say this, that there is something to say when the law is silent on something. And when the law allows for a hearing to take place, that hearing procedures are usually with the body to determine how it's going to run that hearing. So if there are provisions that require at least a part of something, it doesn't mean that it overtakes the whole. And I think that is the way the complaint procedure was created around that point. I will also say that we're talking about interpretation of the law. So if we're going to interpret the law, then I think we should take a position as to what that interpretation is. And it should not necessarily be on a case-by-case basis, because we want it, if we're going to take a position as a set of precedent, then we should take a voted position on it, so that way everyone can enjoy that or get benefit or not from it. So I'm not willing to just say, well, if it's do we know if this overrides the law or not? It's a question. Okay. So at this point, our complaint procedure basically doesn't allow, if somebody hasn't shown up at least once for the hearing to proceed. That's the way our complaint procedure is, and that's the way the task force has voted on this complaint procedure. It wasn't just created ad hoc. It was, gone through our rules committee. It came to the task force. Task force had voted on it. There's been lots of public comment and the ability for the public many, many times to address this. So I'm not inclined to create a new precedent. But if you want to vote, I would ask that we put it to a vote of whether we want to, and then go on the record as, at least to say that we're either going to waive the complaint procedure for this particular case, and do that on a case-by-case basis so it can be heard, or we follow the complaint procedure. Okay. I have Member Forsley and then Member Schmidt.
Member Schmidt, I think, had his hand up before mine.
Okay, Member Schmidt.
Yeah, I'll make the motion that and put it out there that we proceed and we hear the case on the merits and make a decision. If that requires the waiver of the rule, then we also would then say we're waiving the rule.
Is that a motion?
Yeah, that's
Okay.
my motion.
So moved by Member Schmidt. Is there a second?
I'll second it.
Okay. Second by Member Stein. Okay, Member Forsley.
I'm not exactly sure what the motion was. Can you repeat the motion? And then I might have a follow-up question.
Yeah, oh, I'm sorry. You go ahead. Go ahead, Cheryl.
Moved by Member Schmidt, second by Member Stein. The motion is that we proceed with the matter and hear the case on the merits and make a decision. And if that requires a waiver of the rule, then move to waive. Is that correct, Dean?
Yes, it is, Cheryl. Thank you.
Okay, so my follow-up is I wanted to ask Chair Wolf, were you suggesting that we initially, work out a blanket rule to kind of waive this complaint procedure, or do it on a case-by-case basis?
No, I'm asking, based upon what you've been saying and what others have been questioning with regards to what does the ordinance mean, and also based upon Mr. Chafee's assertion. And the question is Mr. Chafee's asserting that it doesn't say in the ordinance that the complainant has to appear. It says that the respondent has to appear. That's what he's saying. The questions that are coming before us in this discussion is, does the complaint procedure override the ordinance? Well, the answer is no, it doesn't. Okay, but then the question is, what does the ordinance say? Is it about attendance to a meeting? The ordinance allows the my assertion is the ordinance allows the task force to have a hearing. And for every other body that is here in the city and maybe elsewhere, if they're given the authority to have a hearing, they also have the authority to determine how they run the meeting and what the procedure is for running the meeting, including whatever the law says is applicable or required. So that's what I'm saying. I will add this, that I'm going to vote no on this only because you're waiving the whole complaint procedure and not the specific section of the complaint procedure. And second, I think that the motion should be to waive just Mr. Chafee's attendance for this particular file, and that all the rest of the other parts of the of attendance still apply. Okay, giving him the benefit of the rest of the complaint procedure, because we're supposed to work with under the interests of the public. Okay, we got a number of hands here.
Excellent point, and I'll amend, just as you asked.
All right.
So that would be that it would be to waive section C, paragraph 7, 7D, requiring an appearance for Mr. Chafee for file number
20068.
20068.
Yes.
Does the second accept that friendly amendment? Member Stein?
Yes. Yes.
I didn't hear that. Who's second?
Member Stein?
Okay, so
she did say yes. I heard her.
Okay.
Yeah, I know. I know. I just want to make sure that I'm understanding how this motion is going to read. It's not going to read as you dictated it originally, Dean. This is now going to be your amendment to move to amend the motion to waive section C, paragraph 7D, requiring an appearance for Mr. Chafee of Mr. Chafee for file number 20068. Is that how the motion's going to read?
Yes, with
Bruce says no.
No.
Well, I don't know if I'm moving to amend. Is that what I'm doing?
No. If you're looking to amend your own motion, you're taking whatever I'm saying as a friendly amendment. If you don't want to take it as a friendly amendment, I'll make a motion to amend it.
Friendly amendment. That's it. Yeah. And yet with the provision that we proceed with the hearing. Still, the same provision.
Okay. Cheryl, do you want me to repeat it?
All right. Because I want to type it in.
Okay. So the motion is to, the full motion would be to, that the Sunshine Ordinance Task Force proceed with hearing complaint file number 20068, and with Mr. Chafee, the complainant, in absentia, and waiving the Sunshine Ordinance Task Force Complaint Procedure, Section C, Paragraph 7, Subparagraph D, for requiring an initial in-person appearance. Okay, let's get back to folks who want to speak on this. I have Vice Chair Yankee, you haven't spoken yet. Go ahead.
Yeah, I guess there was the one question brought up about whether the ordinance requires it or not. I think since the ordinance is silent on whether or not the complainant needs to appear, that basically allows us to promulgate the complaint procedure rules. Obviously, the rules have to include the fact the respondent shows up, since that's in the ordinance. But because it's silent on the fact of whether or not the complainant needs to, I think that does give us the leeway to make the rules one way or another. I'm kind of uncomfortable with waiving this suddenly on an ad hoc basis because, as Chair Wolf pointed out, this was an agendized item. When we discussed complaint procedures, we had a hearing on it. Members of the public were able to comment. Those complaint procedures have been posted on our website for years now. And I think there's a lot of other people who've really, had to put a great deal of effort to make our meetings. And, probably wasn't convenient for them, but they did. And so I feel it's a little unfair at this point to suddenly alleviate that requirement from an individual. If we want to go back and have a robust discussion, about whether we should have that in our complaint procedures, I think I'm open to that. But I'm not sure that on this random ad hoc basis is the appropriate time for one individual. I'm not hearing something like he was in the hospital or he had some extenuating circumstance that wouldn't allow him to come, just that he prefers not to come. And I understand that, but I'm sure, there's a lot of other people who wouldn't rather come to at least the first one, but they did. So I'm just not comfortable, waiving the complaint procedures in this instance. I'll leave it there.
Okay, Member Forsley, and sorry, Member Schmidt, do you have your hand up?
No, let Member Forsley.
Member Forsley and then Member Highland.
Oh, I was just going to say that Vice Chair Yankee said exactly what I was just going to say. Just in all fairness, we should definitely not be doing ad hoc waivers of a complaint procedure. If we wanted to put it on the agenda to notice the public that we were going to be discussing this and taking a stance on this, it could be calendared for the next meeting or the meeting after that. But I think that for the purpose of this particular thing, if he wants to come back and say, well, the law says I didn't have to be here, that could be an excuse for him. But I think that if he's been noticed, that we should just, go with procedure and then take up the broader discussion in the near future.
Okay, Member Highland.
I'm trying to think of a more elegant way out of this, and I'm rereading 7A, where and A comes before D, where it says, at the discretion of the SOTF or its committees, et cetera, accommodations may be made in response to special circumstances or requests made by the complainant. I think right there, this could fall under that, and then you don't have to go and waive anything else. You could make the motion to say that based on 7A, we're exercising our discretion and proceeding with this. Simple as that. It could be read that way also. So I'll just throw that into the mix.
Member Stein.
Yeah, I mean, I do think in his letter, he basically makes the request that, he doesn't think he needs to be here. I mean, it's not a request, but he says he doesn't believe that he needs to be here. And, even though just to your other point about other agencies holding hearings and they require complainants be there, I feel like we're slightly different because of the way the Sunshine Ordinance is written. It's written in this way that we're always giving the benefit to the members of the public and trying to protect the public's right to access information. And I feel like that the fact that it doesn't require specifically the public to be there, to me, is like, I connect it to this issue of creating barriers to people being able to carry through complaints.
Well, I'm in disagreement with that because that's a matter of the interpretation of the law. And unless you have some definitive court opinion or case law that describes otherwise, this has been our precedent. So if Mr. Chafee feels in his letter to us in challenging our procedure in that way, that's a completely different discussion. This is our procedure, what we have here now. And if we're going to say, that's why I asked for a motion, if we're going to waive the procedure, because that is our procedure. It's official. We've been using it for well over a decade. Maybe a decade.
I would like to revisit that procedure.
Right. Well,
I feel much more comfortable saying we strongly, recommend people come. But anyway, I understand that it's our procedure, so, and people should vote accordingly. Wherever they stand on that.
This is Member Highland. I still think that under 7A we don't have to waive anything. We reserve the right, and usually this is to the call of the chair, but in this case, it's the discretion of the task force as a body or its committees to make that action. That's how I'm reading this. And if we agree on that, then there's nothing that's waived.
Yeah, I disagree with that interpretation too, because it speaks for an accommodation. He's not asking for an accommodation. He's just saying that the way he interprets the law means he doesn't have to show up. That's not accommodation, and not a request for an accommodation.
It says accommodations.
Accommodations may be made in response to special circumstances or requests made by the complainant.
Right there, or requests made by the complainant. Read that as a standalone.
Accommodations.
Or requests made by the complainant. You can read it both ways, Bruce.
Accommodations. I don't know. I read accommodations as being some alternative way to have for them to attend a meeting, or if they're under, something beyond a special circumstance. Anyway, I disagree. And okay. I would just say, if there's no other discussion, if we're ready for a vote.
Can we reread the motion?
Member Schmidt, you had your hand up. Did you have something else you want to say?
Just that there have been a couple comments that this is an issue that could be well handled if time were taken, and we were talking about an actual rule change, and I'm open to that, but my feeling is that we can have that as a possibility, but we can't do it right now. But in this case, we're doing a very minor, at least my motion, just as a very minor one-time deal based on the circumstances. And then if people want to talk about changing that rule, then we can do that anytime, and I'm open to that. But for purposes of getting through today's hearing, maybe this is just a provision just for today's hearing. That's all.
Okay, thank you. I'm going to close that. Let's open it up for public comment.
Yes, please.
Can we restate the motion so we're clear what we're commenting on?
Leger?
Yes. Moved by Chair Wolf that the task force.
No. Moved by Member Schmidt. Second by Member Stein.
Moved by Member Schmidt, Second by Member Stein, that the task force proceed with hearing complaint number 20068 with Mr. Chafee, the petitioner, in absentia, in waiving the Sunshine Task Force Complaint Procedure, Section C, Paragraph 7D, for requiring an initial in-person appearance.
Okay. And you can handing public comment over to you.
Okay. Do we have any speakers?
Yes, please.
Ready, sir?
Can you hear me?
Yes, are you ready?
Yes, tell me when to start.
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association. I want to say a few things about these procedures. I believe Member Stein stopped from the reading of the letter on page P73. But he said, I'm not seeking damages. The aggrieved party is the general public of whom you're presumed to be the representatives. The only effect of such a requirement is to create a barrier to enforcement. If the task force uses its position to create barriers to enforcement, then it would certainly be a waste of my time attempting to overcome that opposition. He goes on to say some things that I think everyone should read. The discussion here, I remember years of backwards and forwards and up and down and postponement, staying till 9 o'clock discussing procedures, and then they were put off until another time. This was an exhaustion. Right now, it's already 8:15. If you were requiring somebody to be here for a hearing, they'd be here for 4 hours waiting. It is a huge, huge barrier to the public. They have to go to a scary thing at City Hall with 11 of you looking at them and a city attorney and all this stuff. There are many cases where it's just as plain as day. There is no need to have a complainant. If, for example, somebody says, you didn't, I made a request and it was due in 10 days, and the result has been that 30 days or 40 days or a year later was when the response came, that's pretty self-evident. And I think somebody suggested that there were times when people, they might have a better chance if they're present. But that might not be anything other than a barrier to access to a complaint with them. The law, I think, is extremely clear, and I think Member Stein pointed this out. The last sentence in Section E, an authorized representative of the custodian of the public records requested shall attend any hearing and explain the basis for its decision to withhold the records requested. There's nothing about the any requirement that the member of the public has to attend. And it is an enormous, it can certainly be an enormous barrier. Mr. Chafee has been, I think, clear. Mr. Chafee was the first vice chair and the second chair of this task force way back when. He's a man of principle. And I think it's very clear the law supersedes anything. The law doesn't require presence. And if you had a procedure that had a typo and said you have to provide 2,700 copies when you only meant 2, you wouldn't be standing there saying, well, gee, our procedure says 2,700 copies have to be provided to us, so we have to stick with it. That would be absurd. And I think you need to follow the law. Thank you.
Do we have any more speakers?
Yes, anonymous, please.
Go ahead, sir.
Thank you very much. So on a principle basis and on what the purpose and intent of the Sunshine Ordinance is, I would very much agree with everything Mr. Warfield just said. And I think it's not just the last sentence of 67.21E, it's also the second to last sentence. Where requested by the petition, the Sunshine Task Force may conduct a public hearing concerning the records request denial. But if the complainant isn't insisting in his complaint that he wants this hearing, then whatever you do shouldn't require him to be there. So I think it's not just the last sentence, it's also that second to last sentence. It apparently appears he's not requesting it. And so there's no reason that you shouldn't be able to investigate it without him. And I say that And on that basis, I think that this motion is absolutely right. And unfortunately, I would also agree with the chair and vice chair, though, that, what would other people say? Like, maybe everyone's going to want this. I strongly believe you need to completely change your complaint procedure not to include this. My understanding is from before my time is that, like, for example, the city attorney's office sent you a letter saying this particular complainant, she was also all these other complainants. And because of this, you should change your procedure to be harsher against anonymous or pseudonymous complainants. I remember this only because I've read it through your own public records. I think that's just an example of the city trying to have SOTF make it harder for people to enforce the Sunshine Ordinance against the city, when in fact it should be as easy as possible wherever possible. And on that basis, I think the one-time waiver makes sense, because practically, probably no other complaint's going to complain. They're going to ask you to change your rules, as I think you should. Thank you.
Do we have any more speakers? I think that's it, Chair Wolf.
Thank you. All right, public comment is closed. I have one last thing just to say on this, and that is, I'm not necessarily in agreement with the last two speakers, and for this reason, that when a body is given the authority to have a hearing, and it is silent about how that hearing should happen, then it's basically giving carte blanche to the body to be able to run the procedure or create a procedure and process however it sees fit. To me, what the law is saying is that however you do that, the respondent must show up. There's a requirement that you must include in your procedure, whatever it is, that the respondent must show up. If you want to not have a complainant show up, fine, you can do that. But it's based upon how you want to run the procedure itself. I think when the law is silent on that, it doesn't mean that it just means the opposite. And I think in this case, I think that it's speaking very clearly that the task force has the ability to do that. My concern is, if we do away with this particular requirement, we're going to end up with twice as much work and backlog, because people may feel, because we don't have their testimony, we just have their whatever they submit as a record, that many cases won't go their way, and we would have a very difficult time giving the public the benefit, and we'll end up with more reconsiderations, which is going to take even a longer amount of time beyond the backlogs that we have to deal with presently. So I'll stop there. If there's any other last comments, I'll take it. Otherwise, are we ready for a vote? Okay, let's call the roll.
Member Schmidt?
Aye.
Member Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Member Frazier, absent. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Nay.
Member Neighbors, no. Member Forsley?
Nay.
Member Forsley, no. Member Wong?
Nay.
Member Wong, no. Member Yankee?
Nay.
Member Yankee, no. Member LaHood?
Nay.
Member LaHood, no. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Nay.
Chair Wolf, motion fails. No, wait a second.
Yes.
It's
4
no.
ayes. 4
Six
ayes, 6 nays.
nays, yeah.
The motion fails. So we will go with our complaint procedure C7B, and the matter will be filed and dismissed without prejudice. And Mr. Chafee has 60 days to request that it be reopened. It must do it in writing. If it goes beyond the 60 days, still has the right under our procedures to refile the complaint at a future date. Okay, let's, and Ms. Lachey, we're going to have to send a communication to Mr. Chafee on that.
Yeah, I understand that.
Okay, great. Let's call the next item.
Not yet. I just want to finish typing this one thing.
Chair Wolf, may I ask a question?
Who's speaking?
This is Member LaHood.
Yeah, if it's just like a point of information.
Yeah, point of information. Did someone, an administrator, change the settings on Teams here? Are you all seeing a grid or just the speaker?
I'm seeing 4. I see 4 boxes.
Okay, then I think it's a Wi-Fi. It's a bandwidth issue. Never mind. Thank you.
Yes, but my
Mine keeps
screen
jumping
is
back and
also
forth.
flashing.
My screen's flashing too, and I can see a grid, but I can't see everyone who's on the call. Like I can't see all of our members even.
Yeah,
no.
I'm only seeing the speaker.
Mine's not changed at all. Everyone's there.
Okay.
Bruce, you're on mute.
I'm not on mute.
Something happened. You were talking.
Me?
I can hear you now, yes.
Okay.
Okay, are we ready for the next case?
Well, we'll just.
Yeah, Bruce, I'm not hearing you.
Looks like he's frozen.
Yeah. No, he's not frozen. I just can't hear him.
Oh.
No. Didn't hear that. Didn't hear that. Are you guys hearing this? Lila, Dean, Laura?
He looks frozen to me.
He's starting to move. I think he's starting to thaw.
He's back.
Did you lose your internet connection? Oh, CW's leaving. What's that?
Coming back.
Oops, looks like he dropped off now.
He's probably going to log back in. Remember, Yankee, Vice Chair Yankee, do you want to take it
Sure,
from here?
yeah. I'll continue until he comes back in. So it's just, let's go ahead and have the next file number read, Cheryl.
Okay. Item number 7, file number 20033. Complaint filed by Anonymous against Mayor London Breed and the Office of the Mayor for allegedly violating Administrative Code Section 6721, 6729, by failing to keep or cause to be kept a compliant Prop G calendar.
All right, and is Anonymous present?
Anonymous is present.
Great. Okay, and is someone from Mayor London Breed's office present? Anyone from Mayor London Breed's office? Press star 6.
Mr. Heckle, are you available?
Yes, hello, this is Hank Heckle from the mayor's office. I'm here. Thank you.
Okay, great. All right, so I think we go ahead and get started. And Anonymous, it's going to have, 5 minutes? So Cheryl, when you're ready.
Anonymous, are you ready to speak?
Sorry, isn't there introduction by the complaint committee, or do you want me to do before that?
Oh, yeah, we could do that.
Let me
Complaint committee,
Let me read that. On December 15, 2020, the complaint committee found jurisdiction that the records of public and referred the matter to the task force.
and Member Schmidt, did you have anything to add as the chair of the complaint committee?
First, I'll defer to my members for any comments they have. Anything from either? I think this is, I'll just say it's one of the Prop G calendar cases, and it looks a lot like other Prop G calendar cases we've seen. And I don't think it was that difficult for us to find what we needed to do in the complaint committee. I'm not sure if there were discussions apparently between the petitioner and the respondent to see if they could resolve their differences. We may hear more about that. I'm not sure. Any other comments from members of the committee on this?
Not really, other than to second that I would like to get an update from Anonymous about anything that they received or any changes that they saw after our complaints meeting.
All right, sounds good. And it looks like, is Chair Wolf back?
I don't see him.
I am. I'm here. Can you hear me?
Okay, great. So
now we can hear you. Okay.
So Chair Wolf, we moved on to file number 20033, and Anonymous is just about to begin with his opening remarks, and then I'll let you take over from there.
Okay, great.
So go ahead, Anonymous.
Please let me know when the time begins. Somebody's typing if they could mute.
You ready, sir?
I am.
Go ahead.
Thank you very much. So we'll begin on page, somebody could mute, please. We'll begin on PDF page 115, which is footer P209. I think it's Miss Leger, if you could mute, please.
No, it is.
So, okay. So it's very hard for me to speak over someone typing. Okay. So on the top of that slide, the very first complaint I brought here showed that the mayor wasn't, 19047, that the mayor wasn't disclosing all of her calendars, past calendars. In 19103, I showed that the mayor wasn't disclosing her future calendars. And today's case is about whether or not the mayor is complying with all of the requirements.
Can you, hold on. Just stop the clock. Whoever is the phone caller 6151, you need to mute, please. Victor, if you're still there, can you mute 6151, please?
I will take care of that.
Thank you. All right, can we restart the clock, please?
I'm still hearing stuff in the background.
As am I.
Yeah, waiting for, there it goes. Nope, not yet. Not muted yet. There it goes. Okay, let's restart the clock and
Start from the beginning.
Yeah, from the beginning. My apologies.
Miss Leger, please let me know when I may.
Yeah, I will. I'm just setting the clock.
No worries.
All right. Are you ready, sir?
I am.
Go ahead.
Thank you very much. So this is page 115 of the PDF, which is footer page P209. And just for some context, 2 prior complaints I brought before the SOTF were about whether or not the mayor was disclosing all of her past calendars, whether or not she was disclosing all of her future calendars. And today's case, 20033, is about whether even her Prop G calendar complies with the law. So the bottom of the slide shows you one of the multiple subsections of Prop G calendar requirements. The mayor, it's not her office, it's the mayor herself, as we discussed in one of these other complaints, shall keep or cause to be kept a daily calendar that has the time and place of the meeting, and the calendar shall include a general statement of issues discussed for each of the meetings that's not publicly recorded. So if it's not a public meeting, they've got to record the issues that she discussed. So next page, and we're just going to dive right into them. And you might notice these dates are in 2019 because this complaint is very old. So this is a meeting between Mayor Breed and Superintendent Matthews, and there is absolutely no discussion in this Prop G calendar of any issues discussed. Their argument made at some point by some part of the city that as long as you put something in the subject line, that's sufficient. That's not true. The people who wrote the Sunshine Ordinance were very smart. They knew people would do that, so they said general statement of issues discussed. So something like budget, teacher union, or school renaming, if it was, say, happening in 2021, might be sufficient. And they do have to identify the mayor's office staff that attended the meeting, unless the only people at the meeting are mayor's office staff, and that's later on in 6729-5. The next one is especially egregious, meeting regarding policy. That's literally every issue you could possibly have. And even if she has many meetings regarding policy, say one meeting every week, each week she's going to discuss different issues. And Prop G is an after the fact recording requirement. So after the meeting occurs within 3 days, you have to say what happened at this meeting. And she's not saying what happened at this meeting. This is completely useless for the insight of the public. Next page. She has periodic senior staff check-ins. And each time that meeting occurs, different issues are discussed. Now, in this case, she can say mayor's office staff because they're the only people there. But that is not an issue discussed, and their argument that recurring meetings don't need any kind of information has no basis or citation to law. So each week or each month that she has this meeting, if the issues discussed are different, she needs to give a general statement of issues, plural. It's not issues. If there are 3 issues, she needs to list them. Next one, she had a meeting with the mayor of Heidelberg. We have no clue what issues she discussed with him or her. And I believe I know because I found some other public records, but it's not recorded in the calendar. Next page. So it says here's a different senior staff check-in. Do you notice how it's on a different date? But each week that she has a senior staff check-in, we have the authority to know what she discussed. And that's because the intent of the Sunshine Ordinance is stated right at the top of the Sunshine Ordinance, which is that to prevent public officials from conducting public business in secret. And this is a woefully deficient set of entries here. We should have the list of issues discussed. They don't have to go in detail. They don't have to give me an agenda. They don't have to give me minutes because these aren't public meetings under the Brown Act. These are meetings that the public isn't allowed to see. And the only evidence we have of those meetings is the statement of issues discussed. And it is a requirement. She needs to start doing this. And I don't see any excuse for it. The chair of the complaints committee is absolutely right. This is one of dozens of such complaints. But actually, the mayor's calendar generally has even less information than the department heads. Department heads, kind of put a bunch of detail in Outlook, even if some of their events are non-compliant. But the mayor doesn't really do that, right? They're just making this calendar just for our sake. And since they're making this calendar specifically for our sake, that's why the name of the calendar is in Outlook Prop G, Mayor, they should be giving the insight that the people are owed about what she's discussing at her meetings. This is a special requirement in San Francisco only, and the voters should get what they want. No kind of secret meetings should be occurring. And simply telling who she met with is not sufficient under the Sunshine Ordinance. You found this, I think, with the evidence of a single meeting against Dennis Herrera as the city attorney. The mayor has no lesser requirements. I don't have to prove intent, like they're saying, well, they didn't intend to obfuscate or hide what happened. That's not my obligation. I simply have to show that the mayor failed to record this in her calendar. And I think this is evidence that the mayor did not, in fact, record the general statement of issues discussed for meetings that are not otherwise publicly recorded. Thank you.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant? Okay, hearing none, is a representative from the mayor present?
Yes, good evening, Chair Wolf, members of the task force. This is Hank Heckel from the mayor's office.
I want to time you, Hank. Hang on.
Yeah, hold on. I'm just asking if they were present.
Okay, you ready, Hank?
I am.
Okay, go ahead.
Good evening, Chair Wolf, members of the task force. Hank Heckel, compliance officer in Mayor Breed's office, here to respond to this complaint. I would just like to say generally, the mayor and the mayor's office staff, we fully understand our obligations under the admin code 67.295, which is creates what's colloquially known as the Prop G calendar requirement. We fully support full implementation of those requirements in our own office and across the various city departments. It is our practice generally to fully document the meetings and provide date, time, place, attendees, and subject matter descriptions. I think this case is really about a few outlier entries. These are not representative of the calendars generally that we keep in the mayor's office, contrary to what Anonymous said. I mean, he knows that because we've produced probably hundreds of pages of calendar records to him. I know we've produced hundreds of pages of Prop G calendar entries to just various Sunshine requesters over the years. He's received hundreds of meeting entries, certainly over many months. And this particular request, an issue from 2019, this goes back a ways, was for a 2-week period. So that I don't have the exact figure, but that probably covered something like 50 entries. And so Anonymous is focused on, I guess, 5 entries in particular, and we don't really dispute his claims that there could be some more description here and some more detail around these issues. I think these, we're not coming in to say that these are sufficient entries. I think these are just the entries that existed at the time for these particular entries that we produced, and so there could have been an oversight for some of these. Some of these may have kind of appeared self-evident, like the meeting with Superintendent Matthews, but certainly it would be fair to list a general statement of issues there for that meeting, right? Or the meeting with the mayor of Heidelberg was really in the nature of a meet and greet, which is kind of how these, or I believe it's described as a courtesy call, and that's how these discussions with sister city officials are kind of characterized generally. But this is not something that we're not digging our heels in. Where this is not something where we are vehemently opposed to what Anonymous is suggesting. I think we can probably reach some areas of agreement. Rather than, there was some talk with Anonymous about amending the descriptions, but as time went on, we thought it would be beneficial to kind of air this out before the whole task force and get some feedback from the task force, rather than change the calendar and then maybe have to go back and do it again. So we're open to feedback from the task force on these issues. There are some challenges for things like staff check-in calls, for example, is one of the entries. Those occur pretty much weekly, I believe, and they don't have an agenda in advance. Those are staff meetings where it's literally just sort of checking in on the issues of the day. So sometimes it can be challenging to go back and identify after the fact what specific issues may have been addressed, but I think we can make an effort to do that. And same thing for the policy meetings, to list issues retrospectively, like whatever the case may be, homelessness, housing, education, COVID. We can certainly look at doing that. So I think these, the point I want to make is I think these samples, this is a handful of entries out of hundreds and hundreds of entries. These are not representative. These are probably oversights or things that, just got missed. And we're not opposed to amending the descriptions in some cases. And it's not in the record, but I mean, if you reviewed all the hundreds of other entries that are out there from our Sunshine responses, you'd see that there is more detail is provided generally. And I'm happy to address any questions the task force may have. Thank you.
Thank you. Are there any persons or witnesses on behalf of the respondent, or any facts or evidence on behalf of the respondent? Okay, seeing none. I see Member Schmidt.
Yeah, thank you. To the petitioner, I guess I want to ask about this idea that you're somehow cherry picking like 5 examples. Maybe, you went through hundreds and you found the very best ones. Could you give us a little bit more detail about the process by which you generated those examples that you gave to us, and how many things, how many other items you looked at, and did you just pick out the most egregious ones? How did that work?
Certainly. So I remember correctly, this is a very long time ago. And you can look at the dates, and I believe it matches up. So what I had done at the time was, I believe I'd asked for like 2 sets of 2 weeks at the time. So I think the dates on these match up with that. Yes, I'd asked for 2 sets of 2 weeks. And so what I did was I looked at the meetings she had that were recurring, because that's one of the main issues I have. These policy meetings, senior staff check-in meetings, they happen all the time. And so, yes, they are one type of meeting, but that's a legal issue I have for you. That is, just because a meeting is recurring doesn't mean you can't, or you are somehow allowed to skip the rule that says general statement of issues discussed. The other issue, yes, these are in fact a few meetings with other people, but that's how she generally records meetings with other people, like a peer official. I think you can just ask Mr. Heckle, when they meet with, for example, individual supervisors. I believe the extent of the subject lines at the time when this complaint was filed is, it says like meeting with supervisor so and so regarding District X. That tells you nothing about the issues that are discussed. I think they had suggested that meeting with Superintendent Matthews should just say meeting with Superintendent Matthews about education. I think that's my problem here, right? Even if you were to say, okay, we're going to put what that other person does, I don't think that qualifies as a statement of issues discussed. I don't think it helps anyone, right? And so, in my view, that's not cherry picked. These are the recurring meetings. This is how she generally records, and this is what I filed. And so that would be my response.
Just a little bit of clarification on that. So,
yeah,
you give us, a handful, which is completely the right way to go. But I guess I'm wondering, are those the 5 worst? Like, could you find other ones that are also, this bad, or in terms of the subject matter, issues discussed,
sure,
etc.? I think these look pretty bad. But are these the only ones, or can you find 20, 30, 40, 50 more? What is the whole sample size?
Sure.
The whole bunch that you looked at. What do they look like?
Yeah, so I'll actually, I can answer that very directly. The senior staff check-in. It's not that one senior staff check-in. This happens every week. So every single time you see this, you'll see it completely, in my view, meaningless. Every time she has a meeting about policy, you'll see it say meeting regarding policy. Every time she has a meeting with another peer official, it'll look like that, essentially meaningless. So there are meetings that she has that are with a specific subset group, like it'll be like a meeting about homelessness, and so those ones would be, I would say, marginally acceptable. They have like a word like homelessness or something like that, and that's why I didn't bring them up. I still don't think they are great. I think that they are just barely what is allowed. I think that in order, even something like that, where she meets with like the HSOC, you would have the issues discussed at that HSOC meeting, which are different at each HSOC meeting. But I believe they argue that because the word general is there, for example, that would be sufficient. And so that's why I didn't raise those, for example. But by the way, you can just ask. I mean, I don't think Mr. Heckle is lying to you about what other things they've produced. If he has it in this thing, we could look at it. I'm not saying that we shouldn't look at that, but I'm definitely showing you. You said, are they the worst? I mean, there are many of this same level. I don't think you can get worse than this when you don't have any information. So I'm not sure if that answers that.
I think that's what I was looking for. You said there are many at this level, That's the kind of thing I was worried about. No more questions. Thank you.
Member LaHood.
Thank you. Yes, I have a question for Anonymous. So in addition to you've filed this complaint, in addition to seeking a violation, are you seeking corrections on all of the items in this window that you have requested, or are you seeking a violation and a promise of future compliance?
This was discussed at committee. It does not appear this task force can order them to change a public record. So my understanding of what I'm asking you to do is find them in violation, which puts them on actual notice that this behavior is inappropriate, and then review it at compliance to see whether going forward from, if you agree with me and you make that motion, they add more detail to all Prop G events going forward. That's what I'm asking you to do.
Thank you.
Anybody else? I was, go ahead, Member Forsing.
Thank you. I was just going to ask, what is, and I might have a follow-up question. Can somebody just repeat the violation that Anonymous is alleging?
It's section 6729-5 or not complete Prop G calendar.
Okay. And I guess the question that I have is he's saying that he doesn't like the way that they note the things that they're doing in the calendar versus there's some type of withholding situation. So what I'm getting from it is kind of the former, that he just would rather than put more information in the calendars.
No, this section is specific as to what needs to be in the calendar.
Right, but I'm saying that they provided him with what was in the calendars, but he doesn't like that.
Well, he's saying that it's not compliant with the law. That's the complaint.
Right.
He's not claiming any withholding of documents. No.
Right, that's what I figured. So he just doesn't like how it's being put into the calendar.
Yeah, this is an affirmative obligation to create
Right.
this calendar, and it has to be out there
A certain way. Okay.
Yeah. Yeah. Do you have a follow-up question?
No.
Okay. All right. I will ask Mr. Heckel if there would be any opposition to correcting these entries.
May I respond, Chair Wolf?
Of course, I'm asking you.
Yeah,
sure.
Thank you. So no, I don't think so, honestly. I mean, I think we are open to amending these particular descriptions. We, rather than sort of go around with Anonymous and in terms of, what level of detail he might accept, we wanted to discuss this at the task force. But no, we're not. I mean, as I said, we're not dying on this hill. I mean, I'm not. Those entries are not the best entries. That's the point I was trying to make. And I don't. They're not representative of how the calendar is generally kept. So we're open. For example, on the meeting with the superintendent of the school district and the meeting with the mayor of Heidelberg, we can try and piece together, if there are more specific issues discussed. And, the things like senior staff check-in, I mean, I need to talk to the team. Again, it's a little bit challenging because they don't have pre-existing agendas before the fact. They're just kind of, beginning of the week, what's going on in the city. And so there may be, maybe a list can be generated after the fact of, one or two high-level issues that were discussed generally.
Okay, thank you. Member Stein.
Yeah, let's see. Yeah, so I just had a question for Mr. Heckel. I don't know if you can answer this, but what does the mayor's office consider to be a sufficient level of detail in addressing issues discussed? And is there any guidance that exists on how to interpret issues discussed?
Yeah, I mean, that's a good question. I don't think there is any definitive guidance either in the Sunshine Ordinance provision or the Good Government Guide or, or any other sources or cases or anything like that. I mean, I think it's kind of a rule of reason that a description that would be sufficient to generally describe the issues discussed. I think the intent of the law is not to be like a set of minutes that goes into great depth. I mean, we have descriptions like meeting with the police chief about public safety, or meeting with the chair of homelessness and supportive housing regarding a hotel status update. That's one entry I'm looking at. We gave a calendar to Anonymous for November 2020 for the first couple weeks, and I think those are fairly representative of the more detailed descriptions that we view to be acceptable. Anonymous has those, and we think that's a better representation of what's appropriate and what we do in practice.
Okay, thank you.
Member Forsley, did you have another question?
No.
Okay. Member Schmidt, did you have another question?
Yeah, just to Mr. Heckel. So it sounds like at the mayor's office, when you get this statement of issues discussed requirement, that's not confusing anyone. It's pretty straightforward, right?
Yes, it's straightforward, but I think the level of detail is not laid out in any authoritative source. But I think there's kind of a general level of description that we think is kind of makes sense on just a common sense level, and that's why I agree that the entries that Anonymous were pointing to don't necessarily, at least a couple of them certainly don't fit that description. I mean, just saying it's a meeting with somebody, with the superintendent is not sufficient. We would need more detail around some type of policy issue like education that was discussed.
Okay, so you're not. It sounds like you're not really having a problem with it. And other people at the mayor's office, they're probably on the same page as you. They understand that they've got to, set forth a statement of issues discussed. So at this point, do you think people get it? What's got to happen here?
Yeah, I think people get it. I think we strive to do that, and I think what we're looking at are a few cases of oversight, and there may be things where specific types of entries and descriptions where we in Anonymous may disagree in the future, but I think we understand the general mandate of what to do here.
Okay, great. Appreciate it. No more questions.
Okay. Last call for questions or clarification. Okay, seeing none, let's move to rebuttals. Mr. Heckel, you have 3 minutes. You go first.
Thank you, Chair. Yeah, just to recap, I think the questions got at a lot of the relevant issues that Anonymous has raised. I'm not saying he was doing anything untoward about focusing on those entries. Certainly, those were the entries that were most lacking from his perspective. And I think, like I said, a couple of them were just kind of inadvertently described. The mayor's calendar, I would say, is obviously she's very busy. It's a very extensive, very full calendar. Any day of the week could have, a dozen, 15, 20 meetings. And so, when you get requests for a whole month of meetings or 2 months or something, it can be a lot of work just making sure the calendar is up to snuff. And we have administrative staff that puts it together, and we have 3 days under the Prop G provision to update the calendar. So it's a little bit of a tight turnaround time requirement as well to update these. So it's possible there were some entries that went out that were lacking, but we would defend our by and large the entries that we put out there. And if there are specific things that Anonymous wants to focus on, beyond the ones he has here, we can always address that. But, and if they're, if the task force has ideas, we're open to hearing them. But I think for example, the November 2020 calendar we gave him some months ago has more description for most of the entries, and I gave you some examples before. So we think that we are in substantial compliance on this provision, and we are willing to correct some of the more marginal cases that Anonymous has pointed to. Thank you.
Thank you. Anonymous, your 3 minutes.
Thank you. Please let me know when I may begin.
Go ahead, sir.
Thank you very much. So I was originally going to file this complaint just on the basis of the senior staff check-ins. And the reason I was going to do that was because I think on the principle basis, I should be able to win on that alone. And that's because they have told you that the reason they don't do it is because they don't know beforehand what issues are discussed. And it's hard to know what issues are going to discuss beforehand. But Prop G explicitly tells you this is an after-the-fact recording requirement. And that's what they have to do. This there's no like, well, it takes some work, so you don't have to do it. The voters passed this law to know what every elected official and department head does with their time. And the reason I care most of all about the senior staff check-in, just as an example, is so that every week we know, 3 days after this happens, what are the issues discussed that are at the top of mind at the most powerful person in the city. And we have a right to know that. And that is what the purpose of the Sunshine Ordinance is, that we get to know what the public officials do in public business on the public's behalf, what they meet about. And then if we see, hey, the priorities of the mayor don't match mine, I can say something about it. But even if they were to correct us with just one word, education D9, I don't think that's sufficient. It's definitely not sufficient here. And so one thing I would agree with Mr. Heckel is, if you agree with me, please make a motion to find violation of 67.29-5A, and it's only against Mayor Breed, it's not against Hank Heckel or the Office of the Mayor, for failing to record a general statement of issues discussed for every meeting. And and I would suggest, maybe not in the motion, but maybe just in a suggestion, say what you think should the level of detail you think in your interpretation of the law is required. And then we would obviously, I hope, review that at compliance if you agree with me. So again, please find Mayor London Breed alone in violation of 67.29-5A for failing to record in her daily calendar a general statement of issues discussed for every meeting. Thank you very much.
Thank you. Okay, members. Time to deliberate and come up with an action.
Public comment.
Oh, there's no motion yet. All right, calling for a motion. I'm gonna push you ahead. It's 9 o'clock.
This is Member Wong.
Go ahead.
So I'll make a motion to find violation against Mayor London Breed in the Office of the Mayor for violating 67.29-5 for failing to keep a compliant Prop G calendar.
Okay, moved by Member Wong. Is there a second?
This is Member Neighbors. I'll second.
Moved by Member Wong, second by Member Neighbors to find a violation. The mayor and the Office of the Mayor, the violation is 67.29-5 for not maintaining Prop G calendars in compliance with the ordinance. Is that right?
London Breed in the Office of the Mayor.
Yeah, that's what the maker of the motion said. Okay, Member Yankee.
May I just suggest that we include in the motion for not including a general statement of issues discussed, so that it's clear the specific problem that we had with the Prop G calendar entries.
This is Member Wong. I'll accept that amendment.
I'm sorry, what did you say, Matt? I didn't hear that. For not including specific what?
I'm reading directly from the thing here. It says, for not including a general statement of issues discussed.
And member Neighbors, do you have any issues with that?
Good addition.
Okay. Anything else, members, before we go to public comment? Okay, let's open public comment. Ms. Leger, you have the clock.
I wish to make public comment.
Do we have more than one speaker?
Yes, please.
Two. Okay. Do we have another speaker?
Yeah, we have anonymous one.
Okay. Anonymous, go ahead.
My comments are fairly broad ranging. My recollection is that many years ago, a similar issue came before the task force regarding, I think it was Mayor Lee's calendar. I don't remember more than the vaguest details of that. My vague recollection is that the task force did find Mayor Lee in violation of the Sunshine Ordinance regarding his calendar. Other question I have is, it's sort of off topic possibly, but does the Sunshine Ordinance cover sunshining the participants of the meetings to get their notes for such meetings? That's another question I'd have for the task force. And the other question I would have, I also vaguely remember, are there any exemptions for participants in these meetings other than the mayor's staff? So I think those are all my questions that this is raising in my mind. I hope I can get some insight from the members of the task force as to the the kind of broad-ranging issues this raises in my mind. Thank you.
Second speaker, are you ready?
Yes, just let me know when to start.
Go ahead, sir.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and also P.O. Box 17044, San Francisco, California, 94117-0544. First of all, I'd like to say that we don't have a role in this, and we're particularly familiar, but we certainly think this is an important complaint and support the motion with this caveat, and that is, I think it should say that, as Chair Wolf, I'm glad to say, pointed out, any objections to fixing past incomplete, inadequate entries. I think that's critical. Otherwise, you're encouraging, if you only say going forward, then what you're basically encouraging is city agencies can do whatever they darn well please, including violate the law in the most flagrant way, until maybe on the possibility that somebody will come along and point out the violation and then have the gumption, the talent, the skill, the grit to go through all of the things that it takes to bring a successful complaint. And then, well, then they can change it. And maybe if they change it, it'll be okay. And then, and on and on. And, if they violate again, then we can start another round. So I think it's very important when there's a violation that the violation be fixed to the degree that it can. Obviously, if it's a meeting, the meeting presumably can't be held again, although there might be other things that could happen. but certainly documents. One of the things that I find kind of surprising and even shocking is that I'm looking at these so-called calendars, and they all have the same 6 subjects. Subject, location, start, end, recurrence, organizer. There's nothing that says subject or subjects discussed. It isn't even a blank on the form. And that, I think, is a sign of systematic or likely systematic
30 seconds.
problems. Now, Member Schmidt said something that I found interesting but also troubling, and that is how much are these examples of just a few things, or how much does it represent from the whole? Anonymous is not required to do a full-scale audit. He's not being paid for that. And I think even if it was only these, then that would be significant anyway and be a violation. Certainly, I think all of them should be fixed in accordance with the law, and that should be added to the motion. Thank you.
Any other public comment? Last call for public comment. Okay, public comment is closed. Any last thoughts, members? Are we ready for a vote? Hearing none, please call the roll.
Member Wong?
Aye.
Member Wong, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Frazier, absent. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
No.
Member Forsley, no. Member Schmidt?
Aye.
Aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation against London Breed and the Office of the Mayor for 6729-5 for failure to keep a Prop G calendar and for not including specific general statements of issues discussed. Second by Member Neighbors.
Who was the tally?
I'm missing. 9 yay, 1 no.
Thank you. Please call the next item.
Could I ask a question of Cheryl? She said a specific general
Yes.
statement of issues. Was that the motion?
Yeah,
Specific
please.
general?
Yeah, that was not what was stated.
Because those are opposites.
Exactly.
Did I get it wrong? Well,
Take out specific. It wasn't my motion, so I don't want to. It just sounds like it's not how the motion was stated.
Member Wong, did I state that incorrectly?
Do you mind repeating it again?
Motion to find a violation against London Breed and the Office of the Mayor for 6729-5 for failure to keep a Prop G calendar and for not including specific or general specific statements of issues discussed. The general should be taken out.
It was Vice Chair Yankee that provided that additional.
If I may, yeah. The language specifically, Cheryl, from 6729-5A.
Failure to keep a Prop G calendar and for
Right.
not including specific.
No, not specific. A general statement of issues discussed.
Right. Okay, so you want me to take out the specific? I'm asking Member Wong.
Yes.
All right.
Okay.
Okay.
Got it straight? All right, good. Let's call next item.